For pronouncement of judgment. WA 4 of 2021 with WA 4 of 2022.
Both the writ appeals are dismissed. Yes, any mention?
May I please, my lord? My
Yes.
lord, hearing item 22. Lordship, we have consensus prayer. Lordship, if this may be listed on 20 April, Lordship.
20 April.
Lordship.
What is this appeal about?
Lordship, this appeal is against conviction, Lordship.
I'm asking him.
Lordship.
You're mentioning, so that tell me what is the
Yes,
appeal about?
It's against conviction under 376, Lordship.
376.
Lordship.
Appeal filed by the
Convict, Lordship. Yes.
Okay. As paid for by learned public prosecutor and unobjected to by the opposite party. List the matter for hearing again on
20, Lordship.
24, 2023. Yes.
Lordship, item 24, Lordship. If this may kindly pass over to tomorrow, Lordship.
Who's for the appellant?
My lord, I'm appealing.
Yes, what do you say?
No objection, my lord. Pass over for the day.
You're the amicus. Are you the amicus curiae?
No, my lord. My lord, I'm led by Pius Lutha here.
But this is an appeal from jail. That is why I'm asking you. Appeal from jail normally are conducted by the amicus curiae.
No, my lord, he was personally engaged. Personally engaged.
As paid for by learned public prosecutor. List again tomorrow.
Obliged, Lordship. Lordship, I may be also allowed to mention item 20, Lordship.
20.
Lordship.
Yes.
If 4 weeks time may be given for compliance with the order of the Honorable Court passed by this court, Lordship.
You're appearing for?
Respondent, what the respondent, Lordship?
What do you say? Mr.
Kiangami, Lordship.
Kiangami, Learned State Counsel, appearing for both the respondent, submits that 4 weeks' time may be granted to the respondents for compliance of the court's order. Stop the prayer is not objected to by Learned Counsel for the petitioner. Next para, in view of above. 4 weeks' time is granted. Petitioner, the respondents to file their compliance affidavit by 4 weeks. Yes.
Much obliged. May I please, Your Lordship? My Lord, I beg to mention item number 10. Kindly allow me 3 weeks' time to file affidavit, my Lord.
This is civil revision.
Yes, my lord.
All right, in the prayer made by learned State Council, 4 weeks' time is granted for filing affidavit in opposition. List after 4 weeks.
Much obliged.
His Lordship.
Yes.
Lordship, I beg to mention item number 23, Lordship. I'm mentioning on behalf of Mr. Tang Chuba, the Ring Council. Lordship, that has come up after 2 weeks, Lordship. There's some difficulties today, Lordship.
Okay, as paid for by the learned council. As paid for on behalf of Mr.
Tang Chuba.
Priyan Chuba.
Lordship.
You were there also in this case?
Yes, but he is the leading counsel.
Matter stands adjourned for 2 weeks.
Obliged, my lord.
One thing, who is for the claimant?
Lordship, here we have sent notice, but they have not come.
So, the proceeding is directed to be gone, to be taken up ex parte.
Lordship, on the last occasion, this Honorable Court has passed that this Honorable Court was pleased to pass an order stating that the service upon the respondent are complete,
Complete.
and it's posting and the matter is posted for hearing.
Okay. Was it contested before the trial court?
Yes, Lordship.
Before the tribunal?
Yes, Lordship.
How much is awarded? Why have you filed this appeal?
Lordship, we have filed this appeal on several grounds, Lord. Lordship, here, claimant, there were two vehicles involved, but the claimant is taken the two vehicles involved, but the claimant is claiming from the
Appellant.
vehicle from the appellant only, and not from the
I
vehicle.
see.
the
So
other
you
vehicle.
want apportionment
Lordship,
of
Lordship.
liability.
Yes, Lordship.
Liability should also go to the other insurance company.
Yes, Lordship.
Why is the appellant not, the claimant not contesting?
Lordship, I'm not a word, Lordship. Since we have taken steps in the IA also, through publications also, and through registered post also, and in the main appeal also. And they are not, none of them residents of
All right, okay,
No,
after
no,
2
no.
weeks, after 2 weeks.
Obligement.
Please, Your Lordship.
Yes.
I beg to mention item number 13, Your Lordship. I'm for the respond number 4. So kindly grant me another 3 weeks' time to file my counter, Lordship.
Have you spoken to the other side?
Yes, Your
13,
Lordship.
13. Mr. Jamir is there?
Lordship,
They want 3 weeks' time.
Lordship, it's okay, I have no objection.
As paid for by Ms. Esther, Learned Counsel for the respondents. Further 3 weeks' time is granted to file affidavit in opposition.
Interim order may continue.
Interim order passed earlier to continue in the meantime.
Much obliged, Lordship.
Yes.
May I please, Your Lordship. Lordship, I beg to mention item number 9, Lordship. Lordship, here today I have some difficulties, Lordship. So if this matter can come up after 2 weeks, Lordship. I have already informed the...
Criminal revision.
Yes, Lordship.
Why not appeal?
Lordship, here the...
Charge was admitted.
No, Lordship, he pleaded guilty,
He
Lordship. Yes,
admitted,
Lordship.
that's why. On the prayer of Ms. Lucino, Learned Counsel for the and not objected to by the other side. List the matter again after 2 weeks.
2 weeks, Lordship. Much obliged, Lordship.
Lordship, I'd like to mention item number 17, Lordship. On behalf of Mr. S.S. Day, the leading counsel, Lordship. If this matter may be listed for admission hearing, Lordship. In this IA, we have raised question of maintainability of the
Mr. Day will
repercussion,
come or what?
Yes, Lordship.
He's Advocate General there in Tripura.
Yes, Lordship.
Will it come to, he has forgotten Gauhati, Nagaland, I think.
Lordship, a date may be fixed, Lordship.
When do you want it?
18, Lordship. If it's
18.
convenient for the opposite party.
18 of what?
18 of April, Lordship.
Lordship, I think, Lordship, my senior will have difficulty that week,
So
Lordship.
you come to a consensus, which date is convenient for both sides?
In that case, first week of May, Lordship.
First week of May, Tuesday,
Lordship.
2nd May,
Second May.
Second May.
Lordship.
as agreed to by the parties. This is the matter again for admission on 2nd May 2023.
Lordship, in the
One-
meantime,
Yeah, in the meantime,
interim may
all
continue.
right, the
Lordship.
interim order passed earlier to continue till then. One aspect of the matter you'll have to address is whether CPC will be strictly applicable in this case,
Lordship.
in respect of writ petition.
Lordship.
As you have mentioned, all this provision
Lordship.
to dismiss the writ petition.
Lordship, yes.
Anyway, yes,
Much obliged.
Much obliged.
Your Lordship, I beg to mention item 5 on behalf of Sir L. Iralu. Lordship,
where is Mr. Iralu? I have not seen him for a long time.
Lordship,
Where is he?
due to some difficulties, he was unable to come.
Okay, so what do you want?
I pray this matter be adjourned for another 2 weeks.
Yes, any objection?
No objection, Your Lordship.
All right. Mr. El Iralu, learned counsel for the petitioner, is reported to have some personal difficulties to appear before the court today. Stop. On a prayer made on his behalf and not objected to by the opposite party, matter stands adjourned for 2 weeks. Yes.
Much obliged. May I please, Your
Yes.
Lordship? Lordship, I beg to mention item number 14, Lordship. Lordship, I'm mentioning on behalf of my colleague, Livika Lordship. Lordship, she has instructed me that she will be appearing for respondent number 2, 3, 4, and 5, Lordship.
Where is she?
She's not keeping well, Lordship.
And so?
So she will be appearing for respondent. she
All the
has-
respondents?
Not for all the respondent. 2, 3, 4, and 5.
Okay, 2, 3, 4, and 5.
Lordship, I'm appearing for respondent number 1. I'm for respondent number 1, Your Lordship.
So,
Sometime may be granted, Your Lordship.
have you filed your show cause?
No, Your Lordship, I'm yet to, Your Lordship.
Okay. How much time should you require?
3 weeks' time, Your Lordship, to
All right. Mr. V. Zimomi, Learned Counsel, submits that Ms. Livika, Learned State Counsel, will be appearing on behalf of respondent numbers 2, 3, 4, and 5. And that 3 weeks' time will be granted for filing power as well as show cause reply. Stop. Similar prayer has been made by Mr.
Enangami, my Lord,
Enangami,
for the respondent
who
number 1.
appears for respondent number 1.
Lordship.
Stop. In view of above, matter stands adjourned for 3 weeks. Show cause reply should be filed within that time.
Lordship.
Yes.
Deeply obliged, my Lord.
Lordship, I beg to mention item number 15, Lordship. Lordship, I have instruction to appear for respondent number 2. That is the Director, Food and Civil Supply, Lordship. Lordship, sometime may be given to file an affidavit, Lordship.
Respondent number?
Respondent number 2.
How many respondents are there?
2 respondent, Lordship.
What about 1 then?
Lordship, since I am instructed to appear only for respondent number 2, Lordship.
Let us see the file 15. One Ken is there. Senior government advocate.
Lordship.
Has he come?
Lordship. Lordship.
Yes, Mr. Monchen, you are for respondent number 1.
Yes, Lordship.
What is your prayer? They want time here. Mr. Zimomi is saying he's.
Lordship, since
Oh, Mr. Zimomi's name is also here. Both of you are there, 1 and 2.
Lordship, sometime may be given, Lordship.
May it please your Lordship,
Yes.
I'm mentioning on behalf of the counsel for the petitioner. Since the order was passed by this honorable court on 9/8/2021, let this be the last chance.
No, that is to be seen by the court. See, your duty is to bring it to the notice of the court. That court's order is not complied with. That is enough.
No.
Now let us see what is the direction. What is the order? Do you have the file? Please open the file. What is the order not complied with? Nine eight 21. See, what is there in that order? It just says that you dispose of the representation. How difficult is that?
Lordship, I'm allowed 3 weeks time, Lordship, to get the instruction.
No, not 3 weeks time. Because this order is of which year? 2021, 9821.
Lordship, in that view of the matter, Lordship, let it come after 2 weeks, Lordship, so that we will get a proper instruction.
All right, although Mr. Moin Chen and Mr. V. Zimomi, learned counsels appearing for respondent numbers 1 and 2, respectively, pray for 3 weeks' time to obtain instructions and to file show cause. Considering the direction given by the court way back on 9/8/2021 to dispose of the representation of the petitioner within a time frame, 2 weeks' time is granted to obtain instructions and to file show cause. Yes.
Hello.
Please instruct your clients, Mr. Zimomi.
Lordship.
See, they are to dispose of the representation, that's all.
Lordship.
Nobody says that you directly give something, give that. You have to consider and dispose it off.
Lordship. Hello.
Yes.
May I please, Your Lordship? I beg to mention item number 18.
Yes,
Your Lordship, I would like to withdraw my vakalat number
why?
because of some personal issues, Your Lordship.
What personal issues? What is the matter about?
It's about census.
Correct, census. You are for the petitioner.
Yes, Lordship.
What has happened to the Supreme Court case?
Your Lordship, I have no information about this since I was not there, Your Lordship.
But you should try to find out.
As my senior was handling the issue.
But this is very strange case, okay? I have gone through the files.
Yes, Lordship.
Single bench is directed to make a census once again. Opposite party file appeal. Appellate court says will not interfere. Instead of 30 days, you take 60 days. Now, contempt was initiated that it was not complied with. Then one particular order was passed by this court and somebody has gone to the Supreme Court. It is not even a judgment and order. Supreme Court order says judgment and order. Give me the file, let's see. 18. Who is for the opposite party? What is your good name?
Asal Nawali.
Sanla Wali. SLPs arising out of the final judgment and order 1/3/17. And what is 1/3/17? Considering the facts and circumstances of the case, I find it reasonable to grant time as prayed for. Respondents are given 2 months' time to comply with the order of the court. So giving that 2 months' time to comply with the court's order is taken in appeal before the Supreme Court. How is that? As an officer of the court, please assist the court. If you don't want to take part, okay, it's up to you. We will record that. But at least assist the court because I'm unable to appreciate what has happened here. Because there is no judgment and order on 1317. It's merely an order passed by a single bench of this court granting some more time. Why this matter has been taken to the Supreme Court?
Your Lordship, in the previous case, my senior was handling, and since then I have not received the file. Therefore,
Who is your senior? You take the file now. We'll call it up again after some time. We'll just go through it.
Your Lordship,
Please assist the court.
Your Lordship. Much
Give her the file. Yes, any more mention? No.
For motion, item number 1.
Yes, this is the IA you've been waiting for.
Yes, for amendment, Your Lordship. Like just to bring on record
What are the things you want to come bring on record?
the
Which document?
paragraph 6, Your Lordship. Now, Your Lordship, what has happened in this case, Your Lordship, is that the writ petition was filed by the petitioner challenging the cancellation of offer of appointment issued to the petitioner for appointment to the post of constable in the CRPF, Your Lordship. Now, while undergoing training, their offer appointment was cancelled. And it was cancelled by the respondent number 5, who is the DIG Group Center, Agartala, Your Lordship. But as per the advertisement, terms and conditions, the appointment can be issued only by the Staff Selection Commission, Your Lordship. So one of the ground which was taken by the petitioner in the writ petition challenging the cancellation order was that it was issued even before the final decision was taken by the competent authority, Your Lordship. Now, during the pendency of the writ petition, Your Lordship, the commission has taken the final decision, Your Lordship, and they have issued the cancellation order, confirming the order passed by the
In the writ petition, you have challenged the order of the DIG.
DIG, saying that he is not the competent authority, and in fact, even the letter says that pending disposal of the final decision. So before the competent authority has taken the final decision regarding the appointment, offer of appointment, that was cancelled.
So where's the order?
Now,
The
Your
next
Lordship. And next year, Your Lordship.
Page?
It will run from page 18, Your Lordship. This is the final order. In fact, this also is issued by the DIGP Group Center CRPF, but then based on the letter of the Staff Selection Commission. May I read out, Your Lordship?
Oh, you want to incorporate this?
Lordship.
Page 18 and what else?
18, 19.
19?
There are 6 petitioners, Your Lordship, altogether.
Okay.
So I want to incorporate this, Your Lordship.
18 is the order passed by the DIG, then 19 is what? Original copy?
The type copy, 20 is type copy. This is another petitioner. Altogether, Your Lordship, there are 6 petitioners, Your Lordship. And in the main writ petition, Your Lordship, there are 7 writ petitioner, but petitioner number 1 in the writ petition, he is no more interested to pursue the matter. So his name may be deleted. We are praying for his deletion of his name, petitioner number 1 from the main writ petition, Your Lordship, which I have stated in paragraph 7, Your Lordship.
Page? Okay. Why he does not want to pursue?
In the meantime, Your Lordship, he has got another employment, Your Lordship, alternative employment. Page 14. Page 14, paragraph 7, I have stated that the applicant states that the petition number 1, Sri Rawato Pojar, is no more interested to pursue with the present case and wants to withdraw himself from the case. Therefore, the applicants may be allowed to delete the name of the petition number 1 from the cause title and also from the body in the writ petition wherever appearing. Right. Accordingly, in the cause title of the writ petition, the serial number of the petitioner.
Your application is about 2 things. One is for amendment. The other one is for deletion on number 1. Petition number 1. That's all.
Lordship.
Mr. Gauhati, any objection? No objection. All right. Fair enough. Heard. Mr. C.P. Jamil, Learned Counsel for the
TB Jamir, Your Lordship.
T.B. Jamil, Learned Counsel for the applicant who submits that by filing this application, the applicants who are the writ petitioners in the connected writ petition pray for amendment of the writ petition in the manner indicated in the application. To stop. The Learned Counsel submits that the same is required in view of the fact that certain developments have cropped up during the pendency of the writ petition. To stop. The Learned Counsel further submits that the petitioner number 1, in the meantime, has also secured employment elsewhere, and he's no longer interested to pursue the writ petition. To stop. He therefore submits that name of petition number 1 may be deleted from the cause title. To stop. The Learned Counsel lastly submits that the proposed amendment of the writ petition will not change the nature and character of the writ petition, and therefore the prayer of the applicants may be allowed. Stop. Next para. Mr. Yangawati, Learned CGC, fairly submits that in view of the contents of the application, he has no objection to the amendment of the writ petition as proposed by the applicants. Stop. Next para. Upon hearing the Learned Counsels for the parties and upon a perusal of the application for amendment is hereby allowed. The applicant shall prepare a recast writ petition incorporating the amendments as given in this application and file the same within a period of
3 days.
3 days from today.
Lordship.
Stop. The prayer for deleting the name of petitioner number 1 is also allowed. Stop. Registry to make necessary correction in the cause title. Next para. IA is disposed of as allowed. Now, separate order in the main. In view of the order passed today in IAC number 32 of 2023, the petitioners shall file the recast petition within a period of 3 days from today, after serving requisite copies to Mr. Yangawati, Ladat CGC, appearing for the respondent, Union of India.
Lordship.
Stop. The registry shall also strike out the name of petition number 1 from the arrayed petitioners and renumber the same.
Lordship. In the recast petition, it will be already renumbered, Your Lordship. In the recast petition,
Okay.
which will be.
Okay, then you cancel that part, that paragraph. Huh?
That is not necessary.
It is also provided herein that in view of the order passed in the IA, the recast petition, I don't think it's required.
Not necessary. Your
Okay,
Lordship.
you strike out that, not required that much. Please the matter again, when?
So maybe he'll need instruction 4 weeks, Your Lordship.
After 4 weeks, the respondents shall file their counter affidavit in the meantime.
Much obliged.
Item number 2.
Please, Your Lordship. Lordship, this I is for implement of the new incumbent as a party respondent in
Who is the new
contempt
incumbent?
petition, Lordship.
Who is the new incumbent? Name?
Lordship, one Mr.
Manav Prasad?
Yes, Lordship, the new chief engineer, Lordship.
Manav
of the
Prasad.
project. Manav Prasad, Lordship.
He will become what? Respondent number?
Respondent number 5, Lordship.
Okay. Yes,
Lordship, for respondent number 1 and 2.
1 and 2. Any objection?
No, Your Lordship.
Okay.
Your Lordship, my name has been wrongly recorded in the cause list.
I see. Heard Ms. Lucino, learned counsel for the applicant stroke petitioner, who submits that by filing this application, the applicant seeks impletement of the new incumbent holding the post of chief engineer, Project Sevak Gref, care of 99 APO, whose name is Sri Manav Prasad, as respondent number 5 in the main contempt petition. Stop. She submits that implement of the said person is required for effective compliance of the court's order. Next para, considering the submission made and on perusal of the application for implement of Sri Manav Prasad, Chief Engineer, Project Sevak, Gref, care of 99 APO is hereby allowed. Before that, hereby allowed, right, as respondent number 5 is hereby allowed. IA stands disposed of. Then in view of the order passed today, in IAC number 33 of 2023, Sri Manav Prasad, so-and-so, full address, is hereby implemented as respondent number 5. Office to make necessary correction in the course title. Stop. Next para. Issue notice to the newly implemented respondent number 5, returnable by 4 weeks. Stop. Petitioner to take steps for service of notice upon the said respondent by registered post with AD due within 3 days. Stop. The name of Mr. Gauhati reflected in the cost list. No, cancel that. Mr. Gauhati, learned counsel, learned CGC submits that his name has been wrongly reflected in the cost list and that he's not appearing for the respondents. Stop. Office to strike out the name of Mr. Gauhati as the counsel for the respondent in the cost list, from the cost list. List the matter again after 4 weeks.
Much obliged.
Respondent 5 will be at liberty to file show cause reply. That like.
Item number 4. Item number 3.
Lordship, the issue involved in item, both the item.
This for motion.
The motion are same, Your Lordship. But at the outset, my apology, Your Lordship. In this, there's a typing mistake, Your Lordship. Page number, para 9, page 7, Your Lordship. Page 7.
Yes.
Para 9, third line. Instead of technical, it should have been horticulture, Your Lordship. The mistake is there.
Horticulture specialist.
Specialist, assistant horticulture specialist. The typing mistake is there, Your Lordship. If Your Lordship may please to issue notice, I may be allowed to correct it before the registry.
Horticulture specialist.
And then in the synopsis, Your Lordship, in the first paragraph, second line from the bottom, instead of technical, it should be consultant technical.
Where is that page?
Synopsis, the first page, Your
First
Lordship.
page.
First page synopsis. In the synopsis, first paragraph, second line from the bottom, 16 years, the post of consultant within bracket technical. That mistake is there, Your Lordship. It should be consultant within bracket technical, not technical assistant.
Post of consultant assistant.
Consultant within bracket technical,
I see.
Your Lordship. So if
This one and at page 7.
yes, Your Lordship, that nomenclature is
Which paragraph was that?
para 9, Your Lordship.
Para 9.
Para 9, third line.
Instead of technical specialist?
It should be horticulture, Your Lordship.
Okay. All right.
Oblige, Your Lordship.
Now, what is the case about?
Now, Your Lordship, the petitioner is serving as assistant horticulture specialist, Your Lordship, in Central Institute of Horticulture, CIH, Your Lordship, Metsipima.
Assistant?
Horticulture specialist
Okay.
in CIH, that is Central Institute of Horticulture, Metsipema, which is under the Ministry of Agriculture and Farmer Welfare, Government of India, Your Worship.
It's just near the highway, isn't it?
Yes.
That
ye-
place.
Yes, Gaspani, yes, Your Worship.
Yes.
Gaspani, Metsipema is called Gaspani.
Assistant horticulture specialist.
Specialist, Your Worship. Now, the petitioner is here before Your Lordship because the petitioners
No,
agree.
just a minute. What is it known as? CIH.
Central Institute of Horticulture, CIH. Central Institute of Horticulture.
ICAR. What about
No,
ICAR?
ICR, again, Indian Council of Agriculture and Research.
That's different.
That is part, I think these are all part and parcel of this thing, because this is also horticulture. Because ICR also falls under Ministry of Agriculture.
Then?
Now, the grievance of the petitioner is that the post which is being held by the petitioner is being advertised, Your Lordship. And
Assistant horticulture specialist.
specialist
This has been advertised.
is been advertised. Advertisement, may I take Your Lordship to
But
page-
you're holding the post, isn't it?
Yes, yes.
You're holding that post
Holding the post on contract.
on contract
Your Lordship,
basis.
yes.
They intend to fill up on regular basis.
Lordship. Now, page 27.
Yes.
Page 27, Your Lordship, this is advertisement. Now, the post in question is page 28, item number 3. Lordship has got it?
Yes.
Item, two vacancies for the post of Assistant Horticulture Specialist in Central Institute of Horticulture, CIH, Nagaland Department of Agriculture, whatever, Your Lordship. And Your Lordship may kindly see the 5th line, age given is 35 years,
Yes.
Lordship. Now, the case of the petitioner is that, Your Lordship, petitioner is serving,
And you are 54 years.
Lordship, 50 plus, Your Lordship. I'm,
The affidavit says 54 years.
yes,
So you cannot apply.
yes. Now, petitioner is serving in CIS, Your Lordship, since the year 2007 on contract basis. He was appointed as consultant within bracket technical, Your Lordship. Consultant within bracket technical. I'll be taking Your Lordship to the appointment order.
Yes.
And which is equivalent to the post of Assistant Horticulture Specialist, AHS.
Yes.
And though the petitioner is appointed on contract basis, Your Lordship, his appointment was through a regular selection process, Your Lordship. By regular selection. May I take Your Lordship to page 17?
Yes.
Page 17. Your Lordship has got it?
Yes.
May I read out? This is regarding engagement of 4 number of consultant technical for Central Institute CIH Nagaland on contract basis for a period of 1 year, such and such. Based on approval of the competent authority, applications were invited for engagement of 3 consultants through advertisement in 3 leading newspapers in Northeast region and 2 national papers. We have received 11 applications, of which 7 eligible candidates were interviewed by a selection committee. A selection committee was there, headed by such and such. Third last paragraph, Your Lordship. Relevant. Based on the recommendation, Lordship has got it?
Yes.
Of selection committee, and on careful observation, it is proposed to engage following 4 number of candidates as consultant on contract basis. Number 3, serial number 3 is the petitioner, Mr. Arvind Singh, Your Lordship. Now, it was through a regular selection process. Post was advertised. Selection committee was there, advertised both in local and national papers, Your Lordship. Selection committee was there. On the basis of the recommendation of the selection committee, petitioner was appointed, Your Lordship. Appointment order is page 18, Your Lordship. Government of India, Minister of Agriculture, Department of such and such. Now, this is dated 4th July, 2007. I am to convey the approval of competent authority in this for engagement of such and such as consultant technical. This is the post, Your Worship. Now, his service was extended from time to time. Page 19, Your Lordship. This is the last extension order. Offer of appointment, Lordship has got it. I am to convey the approval of the company notary in the register for extension of service of Sri such and such on the post of technical assistant such and such. Terms and condition number 1. The appointment is purely for period such and such only from 1st September, 11th September 2020 to 10 March 2023, Your Lordship. So his contract service was extended from time to time, and this is the last extension order, Your Lordship. Now, as his extension was only till 10th of March, he has submitted a representation for extension, which is at page 20, Your Lordship.
Yes.
Now, may I take Your Lordship to page 21?
Yes.
Now, this is the detail of sanction post incumbency list. Lordship has got it.
Yes.
Now, the next item is I'll become serial number 2 horticulture specialist. Here, Mr. Anjani Kumar Singh is here, Your Lordship has sent. This is the next item, Your Lordship, the second petitioner. And the present petitioner is, his name appeared as serial number 5, assistant horticulture specialist. Lordship has got it.
Yes.
Now, number of sanction posts, 3 posts are there. Number 1, Mr. Arvind Singh, he is the petitioner, Your Lordship. Now, in CIS, Your Lordship, altogether, the sanction post is total 17, Your Lordship. 17, Your Lordship may kindly note it. Yes. Total sanction post is 17. And assistant horticulture specialist, which has been held by the petitioner, is one of the sanction posts, Your Lordship. Now, may I take Your Lordship to page 23, type page is 24.
Yes.
This letter was written on 7th of December 2011 by the Ministry of Agriculture, Your Lordship, addressed to the Director, CIH. Type copy is page 24, Your Lordship. Now, the subject, if Your Lordship may kindly say the subject is for enhancement of remuneration in respect of Sri A.K. Singh, he is the petitioner in the other petition, and Sri Arvind Singh, technical consultant, the petitioner here in Your Lordship. Page 25, I'll just read out the relevant portion, Your Lordship. Para 2.
Yes.
In view of the above position, it is clarified to CIS Nagaland that these 2 persons, that is the petitioner here and the petitioner in the other case, will be entitled to the enhanced rate of such remuneration such and such, as indicated in Ministry's order number such and such, and will continue to be designated as technical consultant till their engagement in CIS or their adjustment against the post of horticulture specialist. Your Lordship, I am relying on this, Your Lordship. This would also be subject to the condition that CIS Nagaland would not engage at any time personnel in excess of the sanctioned strength of 17%. That is why I've said the sanction which I've read to Your Lordship to note the sanction post. Now, page 26, Your Lordship, this is a representation submitted by the petitioner along with others who are on contract service praying for absorption, Your Lordship. This representation is 3/12/2020, Your Lordship. So, the grievance of the petitioner, Your Lordship.
There are 15 signatories of this representation.
Yes. Other petitions also are there, Your Lordship. Now, the case of the petitioner is this, Your Lordship. No doubt the petitioner is appointed on contract basis. But then the appointment was based on a regular selection process as per the constitutional scheme, Your Lordship. That also is against a sanction post, Your Lordship. And now, after having served for 16 years, Your Lordship, And more so, when even the of Agriculture has written to to the director CS that the post they should be continued till the post is adjusted against the post of horticulture specialist, Your Lordship. Before such adjustment is made, and before that, without considering the representation for absorption, Your Lordship, the post of the petitioner has been advertised, Your Lordship. Now,
See this letter,
Lordship,
24, which you just read out. It says, till they are adjusted against the post of horticulture specialist.
yes,
Correct?
Lordship, yes.
But your appointment is against consultant.
Technical consultant, Your Lordship,
Consultant technical,
Ah,
which
cons-
is equivalent to assistant
horticulture
horticulture
specialist.
specialist.
So
So this letter speaks about horticulture specialist,
specialist.
which is one step higher.
Yes.
And which is in fact occupied by A.K. Singh,
Yes.
not the present petitioner.
Not the present petitioner, Your
So
Lordship.
how do you expect you to be
Now-
adjusted against horticulture specialist?
No, my prayer is this. Okay. In the second case, the petitioner is already horticulture specialist. He has been already selected through a regular selection board, Your Lordship. So his post should have been adjusted. That is one. Coming to the present case, here the case of the petitioner is that at least till such time his post is adjusted against the post of horticulture specialist, he should be allowed to continue. Yeah, okay. Since my submission will be same, may I take Your Lordship to the other case, the
No,
facts?
The other case is regarding
All same,
horticulture specialist.
all same, Your Lordship. He was also, the petitioner in the other case was also initially appointed as consultant technical, Your Lordship. And thereafter, Your Lordship, again, the post was advertised. The post of horticulture specialist was advertised.
Yes.
He appeared in the interview along with the petitioner. And then he was selected because there was only one post and the petitioner was kept in the waiting list.
Selected as on contract
Horticulture
basis.
specialist.
On contract basis.
No, on contract basis. That also on contract basis.
On contract basis.
And then his post again is advertised, horticulture specialist. That is the thing.
So it's the same thing.
Yes.
He was appointed as horticulture specialist on contract basis.
No, initially as, may I take the facts, may I, little difference in the facts,
Initially as what?
consultant technical.
I see.
May I take Your Lordship to
Then
the
he was
second?
given promotion.
Yeah, no, through advertisement, through a selection process, again, he was appointed as horticulture specialist.
Okay.
But whereas, as
There were two selections.
there were two selections,
First, he was appointed as consultant.
consultant,
Thereafter, another advertisement, he was appointed as horticulture specialist.
yes. Actually, Your Lordship, going by that ministry letter, instead of advertising that post, he should have been adjusted against the post of horticulture specialist. But he was made to appear before the selection committee.
Correct. So you have already appeared and he already selected.
He appeared, he was selected. And then now he should have been adjusted, but then even his post, horticulture specialist, that is the second item. So that is why I have made separate petition, Your Lordship.
So let me tell you
Lordship,
whether I have understood correctly or not.
Lordship.
The other writ petition, there were two selections. One is as consultant. That person appeared, got selected on contract basis. Subsequently, instead of adjusting him as horticulture specialist, this horticulture specialist post was advertised. He participated and got selected
Yes.
and on contract basis.
Yes.
Now his prayer is that he also should be adjusted.
Yes.
Instead of now advertising the post of horticulture specialist, he should be adjusted.
Yes.
Because his contract appointment was routed through proper selection.
Yes.
Similarly, the present case also.
Yes. And just to satisfy.
So what is the procedure otherwise?
Yes.
In the first place, why did they fill it up on contract basis? If they want to fill up this in this manner,
Correct. Asking them.
is there any separate provision as such?
No, Your Lordship. May I just refer to two case laws, Your Lordship, where, of course, facts will be little different, Your Lordship. In fact, to go through the selection process, the same selection process twice, Your Lordship, but when they are already overaged.
So what is the last date?
Last date is 30th. This is for submission of form. Selection, it may take, this is just for submission of form.
Correct.
Last date.
So submission of form last date.
Last is 30th, 30. Yeah, submission of form. But then by
30 of this month.
yes, by that time the process examination will take time, Your Lordship.
So what is the scheme of the advertisement? What do they say?
Your Lordship.
Test will be, interview will be held, test will be held, or something like that. What is the scheme?
Regarding the scheme, Your Lordship, the examination, that part, since the petitioner is not already over age, and yes, we have not bothered to go through this. The scheme.
No, but you want stay of this, isn't it?
Lordship?
You want stay of this advertisement.
Yes, so in
So-
respect
so-
of the post in question.
That is why we should know what is the scheme of this proposed recruitment.
So the age limit Your Lordship has gone through, that is 35 for assistant horticulture specialist. And for horticulture specialist, the age limit, the maximum age prescribed is 40 years, Your Lordship.
Or
40 years for horticulture specialist, 40.
where is that post? Yes, number 2, isn't it?
Number two.
Number 2, 40 years.
40.
Then what do they intend to do? On which date they will say that selection will take place? That is what I want to know. And where is the last date, which you said that 30th is the last date for submission of form? I think come to page 33. Closing date. This has to be applied through online.
Yes, Your Lordship, by using website Pegasus.
So closing date is 33. Last date for printing of complete submitted online application is 31. Date for determining eligibility candidates.
(31.3).
This is last date for printing of completely submitted online applications.
The exam schedule, Your Lordship, maybe they will give it in the admit card, whatever. Exam schedule is not given here.
All right. So there are how many posts advertised here?
Now,
Joint director,
uh,
horticulture specialist, assistant horticulture specialist, then marketing officer. What about your other persons whose name appear in the representation?
no, they are
15
not.
of
They,
them.
they are not before this court. Only 2 of them.
No. Definitely they're not before this court, but is the post they occupying being advertised by this advertisement?
Your Lordship, that I am not sure, Your Lordship.
No, we can find out just now only. Where's the representation? We have been serving CRH as contractual staff for several years in various capacities. What are those capacities?
The designation is not given. Page 31, 16 post.
Then anyway, so you have shown me that sanction post. Where's that sanction post? 17 sanction post. Horticulture specialist marketing, then joint director.
The sanction post is at page 21.
Marketing officer. Marketing officer is equivalent to marketing specialist?
Marketing.
Economic, what is this? Economic officer.
No, regarding other posts, Your Lordship, I cannot say.
All right.
I cannot say.
Why I'm asking? Because
Lordship.
sooner or later you might find them joining you. That is why.
Lordship.
So
Lordship.
that
is-
we have to also at least apprehend what is going to happen.
One step ahead.
One step ahead. They will
Lordship.
come again. Supposing you get a stay today, they will come.
Lordship is right. Lordship is right. But
So that is why. So what will be the ramification? That is what I want to understand. So your basic case is that you have been selected through open advertisement to the post on contract basis.
Yes.
Having continued as such for a long period of time, your pay also was enhanced by the authority concerned with an observation that till such time you are absorbed to the post.
Yes.
When we're expecting your absorption to the post, suddenly they come up with an advertisement.
Lordship.
And this in fact, considering your service rendered and your age, you're not eligible to apply for that. Even if you want to apply, you are not eligible.
Lordship.
And what is this citation?
Actually, Your Lordship, these are the cases where the first case is 2015, volume 15, SCC 713, Your Lordship. Relevant paragraph. This is a short paragraph. May I read out paragraph 8, Your Lordship?
Yes.
Para 8. Pursuant to the said advertisement, the appellant applied for the post of assistant such and such, and after written test such and such being selected, their names were recommended, and the appointment to the post of account officer will be on contract basis. This is also contract. Now, next, para 9. Thereafter, the Secretary of Himachal Pradesh such and such, by letter dated such and such, forwarded the name of the appellant to the such and such, with a request to consider the medical board to conduct medical examination and are recommended, having found fit, they were appointed in the year such and such to the post of assistant account officer, but on contract basis, Your Lordship. Now, para 10. Having found fit in the absence of any allegation against them, the period of contract was extended from time to time, and now they have completed more than 5 years of service. Here, Your Lordship, I have completed 16 years. That the learned counsel appearing for the appellant's content that all procedure for regular appointment having been complied with, including recommendation by such and such, there was no occasion for the respondent to employ them on contract basis, and there should not have been any difficulty to provide them a regular appointment, Your Lordship.
Paragraph?
Paragraph 11. 11, Your Lordship.
See, is it a bit different?
No, facts are different, but then here, Your Lordship,
because you see, if you come to your first advertisement,
Lordship,
is there any indication that this will be on contract basis?
it was on contract, Your Lordship.
No.
We are appointed.
The judgment which you're referring to here, perhaps they did not mention that it will be on contract basis. They were selected, but now after being selected, they say now you are appointed on contract basis.
No.
Is it your case like that?
No,
Is it
Your
similar
Lordship.
to your case?
No, Your Lordship. But then
that contract appointment was known to you.
Yes.
Isn't it?
Yes.
From the day one, you know that this is going to be a contract appointment.
Contract, Your Lordship.
You accepted it.
That is accepted. But my case is that having appointed though on contract after following due process, regular selection process, Your Lordship.
No, that's a different thing.
Yes.
Those are two things. Now here it seems that they did not know that it was going to be contract.
Understood.
They applied.
Yes.
But after getting selected and appointed, they find that it is contract.
In the advertisement, it was mentioned.
It was mentioned?
Contract, in the advertisement.
Where? Let us see.
Through the first note, like Form 1. Now, what has happened here is that, Your Lordship, the department has requisitioned the post to the Public Service Commission for regular appointment, but in the advertisement, contract was mentioned. A little different.
In which advertisement? In this Arjun Singh's case?
Yes, in this, no. The Supreme Court case, which I'm relying on, Your Lordship.
Yes.
If I'm not mistaken, this is the case, Your Lordship, where the department has requisitioned the post to the Public Service Commission for regular appointment, but in the advertisement, they have given contract. That is the thing.
No, if they've given contract, then it will apply to your case. But supposing there was no mention about that contract, then it might be slightly different.
Now, even our sister High Court, Manipur High Court, Your Lordship, the next case.
No, let us complete with this Himachal High Court first. Supreme Court. Because paragraph 8, which you just read,
In Lordship.
clearly says, therein it was mentioned that the appointment to the post of Assistant Accounts Officer will be on contract basis.
Yes. Para 7, Your Lordship. Para 7, there's However, when the Himachal Pradesh Public Service Commission issued advertisement number such and such, inviting application to the post of Assistant Accounts Officer Class 1, for the reason not disclosed by the respondent, the scale of pay was shown at the rate of 50% of the regular pay and the nature of appointment on contract basis.
So this was by the Public Service Commission?
Yes, that was the otherwise, Your Lordship.
Now, what is the provision under the
Actually, what has happened, Your
relevant
Lordship,
rules?
when the department has requisitioned the post of the Public Service Commission, Your Lordship, it was for regular appointment. But in the advertisement,
So in terms of the advertisement, they were given contract appointment.
Yes.
Supreme Court said that the rules otherwise says that it does not provide for contract.
But even then, Your Lordship, after the principle is this, Your Lordship, what I'm trying to impress upon Your Lordship. After going through a regular selection process, Your Lordship, in fact, as per constitutional mandate.
But these are things
Right.
happening today because of the unemployment problem. Even for muster roll also, they are trying to get some sort of interview and all that. Then he will come tomorrow and say that I've been selected through interview. Although I'm muster roll, you must regularize me. Can it happen? So these things are
I
there.
agree, Your Lordship. But then that is actually the thrust of the case of the petitioner, Your Lordship. Now, para 17, Your Lordship. It is clear that the terms and condition of payment at the rate of 50% of regular payment and nature of appointment on contract basis was inserted in the advertisement by the state authorities and the HP Public Service Commission at the later stages to deprive the candidate from the regular pay and the right for such and such. The High Court failed to notice the aforesaid facts and erred in holding that regulation of service is not permissible. In fact, it was not a case of regularization of service of the appellant, but is a case wherein direction ought to have been issued on the respondent to provide the appellant with order of regular appointment from the date of the initial appointment and to treat the initial period of 2 years as probation and to provide them with other consequential benefits. For the reason aforesaid, we set aside such and such. And that was...
Next case.
And our sister High Court Manipur, Your Lordship, this is judgment order dated 29/28/2018, passed in writ petition number 519 of 2018, Your Lordship. Relevant para 3.1. But relevant portion, I'll read out from page 3, Your Lordship. Page 3, fourth line from top.
Yes.
The registrar, Lordship has got it?
Yes.
The registrar issued a notification for appointment to the post of assistant professor on contract basis in respect of some subject, including humanities, whatever. The petitioners, being eligible, applied for appointment to the post of assistant professor, and after the interview having been held, the selection committee recommended the name of the petitioner for appointment to the post of assistant professor against the post shown against their name. On the basis of said recommendation, the petitioners were appointed on contract basis, whatever, and the contract appointment was extended from time to time, just like the present case, Your Lordship. Now, next page, Your Lordship. Now, para 3.3. The petitioner, to the utter surprise and dismay, the university notified for fresh recruitment of all the posts of the university wide notification dated such and such, and being agreed by it, this is the case of the petitioner also, Your Lordship. The instant writ petition has been filed by the petitioner on the inter alia ground that since the petitioner had been appointed after following the procedure, their appointment was within the ambit, province, and scope of the provision of Article 16 of the Constitution of India, that in terms of the law laid down by the Honorable Supreme Court, the petitioner ought to have been provided with order of regular appointment, and that the initial period of 2 years ought to have been treated as probation. Though the Supreme Court, though the case law is not quoted here, I think this is the case law, because that in the earlier case also that was 2 years probation, Your Lordship. Now may I take Your Lordship to the last page, the relevant page, page 23, Your Lordship.
Yes.
2, 3, 4, 5, 6, 7. The 8th line from top.
Yes.
The finding of the, since the petitioners have already been subjected to recruitment process without the same being questioned by anyone, there is no need for them to undergo another such recruitment process. But here is the case, Your Lordship. In that case, here the petitioner could have participated in the interview, but this is the case where, Your Lordship, the petitioner is already overreached, Your Lordship. In the peculiar facts and circumstances of the present case, this court is of the view that all the petitioner cannot be denied appointment on regular basis for no fault of theirs, and that too after they've been subjected to a long process of recruitment.
All right, so we issue notice. Mr. Gauhati, anything to submit?
No, no,
at this stage? Heard Mr. T.B. Jamir, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the advertisement issued by the respondent authority concerned. What is the date?
Page 27.
Any date?
No date, just website, no website. Advertisement number 5 of 2023.
That is advertisement number 5 of 2023, within bracket annexure 8, through online, correct?
Lordship.
Insofar as the post of
Assistant Horticulture Specialist.
Assistant Horticulture Specialist is concerned. Full stop. The learned counsel submits that the petitioner responded to the advertisement issued for the post of
Consultant Technical.
Consultant Technical.
Within bracket.
Consultant is within bracket.
Consultant Technical within bracket.
Okay, to the post of consultant, then within bracket technical. What did I say? This sentence, please read. For Central Institute of Horticulture, within bracket CIH, Nagaland. On contract basis for a period of 1 year. On contract basis, not for a period, huh? Contract basis. Stop. After undergoing the selection process conducted on 13/6/2007, the petitioner was appointed to the said post, initially for a period of 1 year, and which was extended from time to time. Stop. The learned counsel submits that the post of consultant within bracket technical is equivalent to the post of assistant horticulture specialist. Stop. Over the period of his extension, the Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India, through its Undersecretary, had written to the Director, CIH, Medzifema, Nagaland, on 7/12/2011, permitting the enhancement of the monthly remuneration to the petitioner and another officer Full stop. It was also provided that the petitioner and the other person would continue to be designated as technical consultant till their engagement in CIH or their adjustment against the post of horticulture specialists. Full stop. Since the petitioner has been serving against his appointed post for a long period of time, he along with other similarly situated persons working in different posts submitted a representation for their
Page 26, absorption.
absorption to the posts to which they were appointed or to equivalent posts on 3/12/2020. Stop. While the petitioner was expecting his absorption, to his surprise, the impugn advertisement has been issued by the respondent authority concerned. Next para, Mr. T.B. Jamil, learned counsel, submits that the petitioner has undergone the rigors of the selection process in order to be appointed as consultant within bracket technical, and therefore the respondent authorities are required to consider his absorption to the post or to the equivalent post.
Lordship,
as-
the respondent ought not to advertise the post held by the petitioner till his post is adjusted with the post
Okay.
of horticulture specialist.
Okay, that part you write like this. Therefore, the respondent authorities ought not to have advertised the post which the petitioner is holding till his absorption as assistant horticulture specialist,
As horticulture specialist, till
As-
his horticulture specialist.
not assistant.
No, till his adjustment as horticulture specialist, as per the letter.
Okay, till his adjustment as horticulture specialist
Lordship.
in terms of the communication dated 7/12/2011, 7/12/2011.
Lordship.
Full stop. The learned counsel further submits that as per the impugn advertisement, the minimum age for
35 years.
for applying for the post in question is 35 years. And the petitioner, having served for more than
16 years.
16 years, is by now overaged and is not in a position to apply for the same, even if he wants to. Full stop. The learned counsel submits that no, you cancel that, huh? In support of his submission, the learned counsel has relied upon the following authorities. Number one, Arjun Singh and others versus State of Himachal Pradesh and others, 2015, 15 SEC 713. And number two, Roman 1 and Roman 2, small one within bracket. Number two, judgment and order dated 29/2018, passed in WPC number 519 of 2018 by the High Court of Manipur. In Lorembam Iboyama Singh and 4 others versus State of Manipur and 2 others. Copies I have, you can get it, spellings, everything. Next para, in view of above, issue notice of motion, returnable by 4 weeks. Mr. Yangavati, learned CGC, appears and accepts notice on behalf of
Respondent 1.
respondent number 1 only. Respondent number 1.
All your lordship, they are official respondents, your lordship.
How many respondents are there?
5, you know.
Except this thing UPSC. 5.
I think you can accept for 1 to 4.
1 to
No,
4.
4 is Demo Group.
This director also comes under ministry, union ministry.
Government of India.
Yes. All official respondent except UPSC.
1 to 4. Petitioner to serve requisite extra copies of the writ petition to Mr. Yangavati, if not already done. Post of petitioner shall also take steps for service of notice upon the respondent number 5 by registered post with ADT within 3 days.
Lordship.
Next para, having regard to the projection made by the petitioner, in the interim, it is hereby provided that the respondent authority concerned shall not proceed with the filling up of the post of
Assistant horticulture specialist. One lordship, there are 2 posts or 1 post. 1 post they can go because I am
shall not fill up 1 post of assistant horticulture specialist that was advertised through the impugn advertisement number
5 of 2023.
5 of 2023 without leave of this court.
And your lordship, service of the petition also may not be disturbed, your lordship, because it has to come to regular selection. Otherwise.
No, but your application is pending, isn't it?
Yes, lordship. Page 15, my interim prayer, your lordship, page 15, prayer.
No, that is there. See, but what will happen to your...
So at least status quo as on today. In respect of the post held by the petitioner. If that protection is not given, stay in the advertisement will be meaningless, your lordship. Status quo as on today, I am still continuing.
It is further provided herein that the petitioner is still continuing
Yes.
as consultant within bracket technical as on date, despite the contract period being extended up till 10th March 2023.
Lordship.
Comma, status quo as on date
Lordship.
should be maintained.
Lordship.
So what is the difference in the case?
The second case.
Oh, one more thing, just a minute.
Second case also.
Oh, no. Before we come to the one thing, the learned counsel for the petitioner is permitted to make necessary correction
Lordship.
in the typographical mistake appearing in this first paragraph of the synopsis, as well as
In para 9.
in paragraph 9 of the writ petition
Lordship.
by hand, by
Lordship.
subscribing signature.
My lord.
Right.
Deeply obliged. Deeply obliged.
So what is the difference here?
The difference here, I'll just take your lordship to the annexures, your lordship, starting from page 18. He was appointed as technical consultant 1 year ahead. Page 18, your lordship. I'll just take your lordship to the annexure. So this is the advertisement issued on 11 May 2006. Application are invited for appointment of consultant on contract basis for a period not exceeding 12 months for undertaking various activities in such and such. So consultant 5 post. So this was the advertisement. Pursuant to this, and page 19, your lordship. This is the minutes. This is regarding engagement of consultant for CIS Nagaland. It may be mentioned that advertisement was given in the leading newspaper in Northeast and 1 in national papers, namely Assam Tribune, Nagaland Post, the Shanghai Express, Telegraph, such and such, inviting application from eligible candidates for engagement of 5 consultants, whatever, your lordship. So the same was duly advertised. And page 21, your lordship, type copy. Lordship has got it?
Yes.
This is regarding engagement of 5 number of consultant technical for such and such. Second part. Based on the approval of the competent authority, applicants were invited for engagement of 5 consultant, whatever. These are the committee member. And then page 22, your lordship. Third para. from the bottom, second paragraph. Based on the recommendation of selection committee and on careful observation, it is proposed to engage following 5 candidates, including the first candidate in the waiting list, instead of Mr. Ramesh Kumar Shukla. There were no sufficient supporting documents for consideration of in absentia. So number 5 is the petitioner here, A.K. Singh.
So this is the process of selection.
This is the process of selection. The same process advertised in the national and also in the local paper.
No, which date? On which date?
On which, Lordship, Lordship may kindly turn to page 19, the third line. This is the minutes. It is given the Nagaland Post, Shanghai Express, and the Telegraph dated 18 May 2006. This is the minutes of the
Page?
page 19. Third line, Your Lordship. Lordship has got it?
Yes.
So dated 18 May 2006. So it was advertised in both local and national papers, post.
Then what is an extra page 18 then?
Page?
Page 18 is advertisement of 2006.
Advertisement. Now, this advertisement was published in the local paper, in the newspaper. This is the advertisement, and this advertisement was published in in newspaper, circulated in both local and then national on 18th May.
I see.
Lordship.
11th May is the issuance of the...
Yes. So this was published in the local newspaper, Your Lordship. Now, accordingly, selection committee was there. Selection committee recommended, amongst other, petitioner, whose name appears as serial number 5 at page 22, Mr. A.K. Singh.
And this selection happened on which date?
The selection, Your Lordship.
Is it 14/7/2006? Which you find in page 21?
Page 21. Yes.
Third paragraph?
First paragraph for regarding.
Third paragraph.
Yes.
Out of the 14
yes. Interview held on 14/7/2006. Now, page 23 is the appointment. The appointment order, same step, Your Lordship, as in the earlier case. Appointment as consultant technical, Your Lordship. Now, while the petitioner was serving as consultant technical, Your Lordship, that advertisement was issued, page 24.
Walk-in interview.
Yes. Now, may I read out?
Yes.
As per the advertisement number such and such dated 27/1/2016 that appeared in the national as well as local newspaper, the walk-in interview was conducted. From here, it is clear that for this walk-in interview, it was the post was advertised, published in the local paper also as well as national. Now, this is for the post of horticulture specialist, Your Lordship. Interview was conducted by the selection committee for the post of.
And also assistant.
No.
No, just read. And there were 2 posts.
Oh, okay.
Although you may have applied.
Yes.
You may have applied for horticulture,
Yes,
but
yes.
there was also assistant horticulture.
Yes. And last para selected, Your Lordship. Last 2 line. Selected Mr. Anjani Kumar Singh, he is the petitioner. And then waiting list is Mr. Arvind Kumar, the petitioner in the earlier read petition, Your Lordship. So he was in the waiting list. Now, next page 25. Accordingly, he was given offer of appointment, page 25, to the post of horticulture specialist.
On contract basis.
On contract. And next page 26, Your Lordship, that is the extension, offer of extension of service, offer of appointment. I am to convey the approval of the company notary in this department for extension of service. So this was extended. First paragraph, Your Lordship, with effect from 25th September 2022 to on terms and conditions to 24th March 2023. So accordingly, the petitioner also submitted his representation with request for extension of his service, page 27, Your Lordship. The same case, Your Lordship. And here also, Your Lordship, page 28, type page is page 29. The petitioner he also is relying on the letter that is 7th of December 2011, written by the Ministry of Agriculture to the address to the director. for adjustment.
Where? Which part?
Page 29. Page 29. This is the same letter. It's the same letter. Page 20.
Correct.
Yes, Your Lordship.
It's the
For
same.
adjustment, Your Lordship. For adjustment of the post. Because the post of horticulture specialist. Now, the same representation is there, page 31, Your Lordship.
The rest are all same, isn't it?
These are all same, but here the case is this, Your Lordship. Now, since the petitioner is already appointed through a regular selection process to the post
Twice.
of horticulture specialist, Your Lordship.
Twice.
Yes.
So,
So,
no, the other second one was walk-in interview.
but then, but the selection was there, Your Lordship. Whether it was written, interview, whatever, selection process was there. So, Your Lordship, since the petitioner is already holding the post of horticulture specialist, he should have been adjusted, Your Lordship. Instead of
Against horticulture specialist.
yes, he should have been adjusted instead of advertising his post, more so when he has been serving for more than 17 years, Your Lordship. And he is already overaged.
So similar order. I think it's same,
Lordship.
except for that two times.
And
Selection.
then till not in the first case, till because he was assistant agriculture specialist, till his post is adjusted. But in this case, since he is already serving as horticulture,
It should be adjusted to that post.
he should be.
I got it.
Lordship.
So it will be a similar order. You'll print two orders and give me the file, okay? I'll make the corrections.
Dibya.
Yes. Mr. Jamir, respondents are same, isn't it?
Same respondents. Same respondents.
For admission, item number 6.
May I please, Lordship?
Yes.
Lordship, I'm making mention on behalf of Mr. N.K. Lukham. Lordship, kindly grant 2 weeks' time to file reply, Lordship, to the affidavit filed by the
This
government.
is item
6.
Okay. How much time?
2 weeks' time to file reply,
All
Lordship.
right, as paid for, petitioner is granted further 2 weeks' time for filing reply affidavit. List after 2 weeks.
Obliged, my Lord.
Item number 7.
Yes, pleadings complete?
Yes.
You are there, Mr. Gauhati?
Please commit, Lord.
Huh? Who's for the other side?
Mr. Moa. himself.
Why is it listed today?
For admission hearing, Lordship.
For admission hearing. Can it be heard? Who's there?
Moa.
Legal officer.
Yes, Lord. Under the Department of Prison. Under the Department of Prison.
Prison. Who's the counsel for prison department?
No, Your Lordship, the state respondent is appeared by Moa himself. He is coming, Your Lordship.
Oh, it's 12 o'clock. Give me 5 minutes, I'll come back.
Lordship.
Yes.
Sorry. Lordship, petitioner, she is a law graduate and she was appointed in the year 2009 as legal consultant and has been till the date of filing this, she has been continuously serving for 11 years. As of now, she is continuously serving for 14 years on contract basis, Lordship. Oh, Lordship,
Since 2009. Which
since
year?
2009, she was initially appointed as legal consultant in the year 2009.
Then now?
She is still under contract.
No. Till now as legal consultant.
Yes. No, Lordship,
Name is changed.
as of now, she is taking additional charge of Deputy Director, Prison Welfare.
Since when?
February 2021.
February?
17 February 2021.
Additional charge as?
Deputy Director, Prison Welfare Officer.
Is it a sanctioned post? Prison welfare officer.
Yes, Lordship. Lordship,
Yes, go on. What is your
by
case?
Annexure 8, page 27, Lordship, the department has sent a proposal for extension of service of really boring legal consultant approval thereof. And thereafter, Lordship, next page 28, 9, Annexure 9. A proposal for creation of legal officer was under the prison department was forwarded, Lordship. May I read, Lordship?
Yes.
The prisons department is one of the oldest government institutions in the state and has been functioning without a legal officer. Therefore, the department has proposed to create one post of legal officer since the rate of litigation has been on the increase with increasing crime in the state. With the growing concern of human rights, the National Human Rights Commission has issued directives for having a legal officer in the prison organization setup. Moreover, as per the Model Prison Manual and the Prison Management Bill 1998, a legal officer is mandatory.
So what is the job of this legal officer?
Worship, I'll
This proposal is submitted to whom?
do the cabinet, Lordship.
Cabinet.
Yes, Lordship.
Then what happened to the proposal?
Then page 32, Annexure 11. Page 32, Annexure 11. This is the notification dated 11 November 2014. The Governor of Nagaland is pleased to convey the sanction to the creation of one post of legal officer, class 1, gazetted in the scale pay of so-and-so under the prison department with immediate effect. So sanction was duly copied by the government.
So you are occupying a sanctioned post?
Yes. Then, Lordship, at page 33, Annexure 12. This is a notification. By this, I was appointed on contract basis only. Consequent upon the creation of one post of legal officer, class 1 gazetted under the prisons department in the scale pay of so-and-so, and in the interest of public service, the Governor of Nagaland is pleased to appoint Srimati Riley Boying PALB on contract basis in the spell of so-and-so. So in spite of the creation of a post, sanction post, I was appointed only on contract basis.
Otherwise, you were appointed as legal consultant.
Yes,
But later on, you have been appointed as legal officer
yes,
against the sanction post, but on contract basis.
on contract basis. Now it's
Getting scale pay, but contract is for 6 months.
6 months. It has been extended from time to time.
What is this?
Worship, the prison management bill and the model prison manual provides that a law officer post is mandatory.
So post is there now.
Yes,
they have created.
post has been created, but I was appointed on contract basis only. Though I've been serving in the said post for the last 14 years.
Prison Management Bill, 1998. So what has happened to this bill?
It's enforced all over the state, like in Nagaland, India.
Remains a bill only, is it? There is no enactment as such.
But all the prison department, they are following this model code of conduct and bill.
Model Prison Manual. Where is this from?
What if I wrote just the relevant portion? It's a big book.
No, what is the book about? It's a prison manual.
Yes, it's a manual.
State prison manual.
Yes, sir. I can bring this tomorrow.
No, you have read some sentence here. Moreover, so and so provides for this and that. What is that? Memorandum. As per the Model Prison Manual and Prison Management Bill, legal officer is mandatory. So they have accepted it and they have created this post.
Yes, sir.
Only thing is that they have filled it up by way of contract.
Because the reason why I was appointed on contract was because of the opinion given by the Department of Justice and Law. My Lordship, please.
Where is that?
Page 44, Annexes 17. Lordship,
Yes.
this is Justice and Law Department, Lordship. The file endorsed by the Home Department, Home Branch for legal advice with regard to regularization of contract service in respect of Srimati Rally Prominent legal officer under DG prison has been examined by Law Department. It is observed that the Honorable High Court in WBC number 145K has ruled that the state should not regularize the service of any person who has been serving on contract ad hoc basis in term of the office memorandum dated 11/8/2016 and office memorandum dated 4/8/2008 and declared this office memorandum unconstitutional for being not in conformity with the judicial pronouncement of the Honorable Supreme Court in Omar Devi case. The said judgment and order passed by the learned judge has been upheld by the learned division bench in WA number 16K of 2019. That being the decision of the High Court, dated 3/8/2018 and 7/2/2019, any step taken should be at variance with the direction of the Honorable Court and is liable to attract contempt petition. It says it goes if the petitioner is regularized in a service, it will amount to contempt.
What are these office memorandums? 11/8/16 and 4/8/8.
This is for regularization of contract and set of employees. In any case, Lordship, the petitioner, she was not one of the applicant petitioner in that case. And so the question of attracting contempt proceeding does not arise.
No, that's why I was asking you about the office memorandum. I'm not asking about the appointment. No. Office memorandum covers everyone. So if the office memorandum is held to be unconstitutional, then it would affect everyone who has been appointed in terms of that, or who are seeking benefit under that office memorandum. You may not be a party to that writ petition, but if it covers your case, then see. Now let us see, how did you get into the service? In what manner? Was there any selection? Your name has been recommended.
Yes.
By one DIG of prisons.
In fact, all the officers, they have recommended my name.
Huh?
All the officers, successors, they have recommended my name. For
See, but you know the scheme of the appointment as per the constitution is it should be open to everyone. You cannot recommend one person individually. They may select you ultimately, but the opportunity should be given to everyone. That is the constitutional scheme. So that is why all this Uma Devi judgment and that writ appeal and that writ petition has come. Now, your appointment is extended from time to time.
Yes, yes.
Now, when was the last extension? You have shown me page 33. This is up till 2006, 2014.
Lordship,
15.
if my Lordship may kindly see my affidavit and reply.
Yes, what is that?
Page 9, Lordship. This is order dated 17 February 2021. Order. Srimati Riley Prime Legal Officer, Headquarters, Office of the DG Prison Nagaland, Kohima shall hold additional charge, Deputy Director, Prison Welfare Officer with immediate effect, in addition to our own normal duties until further orders. So, till date, I am still serving the post.
What is the kind of duty and functions that you do as legal officer?
I am legal officer.
Under the prisons department?
Yes, Your Lordship. My Lordship, come to page 25. Page 25.
25 of the writ petition.
Petition, yes. This is a report submitted by the petitioner, Lordship. Details of performance, report of legal consultant. I am to furnish the detailed performance of legal consultant of prison department for your consideration further action. As you are well aware, the legal consultant prison has been engaged on retainer basis
Since
Whether-
October 2011.
Yes.
But you were working since 2009.
Yes,
you
yes.
say.
It's in 2011 only in the report. Why so? To look after the court cases relating to department, that is, cases pending in various court involving the department, cases involving department officers and personnel, cases of staff like suspension, disciplinary action, etc. The exact nature of duties assigned to her was primarily to render professional advice in departmental matter with regard to legal position as and when the need arises. I may add that many departments have been conveniently functioning as per the practices followed earlier, but with public enlightenment and mass awareness, the department is frequently dragged to the court by the aggrieved employees as well as other parties. Various procedures and steps normally followed are found to be lacking and fail to stand the test of legal scrutiny. Consequently, the department is subjected to adverse judgments. The prestige of the government and the department is affected, including severe pecuniary losses to the exchequer. Hence, the need to rectify and ensure proper procedure at every level with professional advice. The department is also implicated as party in many cases. The government advocates are to represent the department, but her service as professional with legal background to license with the government advocates and the department, keeping in mind the interests of the department and understanding of the department perspective as to the fact and circumstances it is deemed to be valuable in protecting the interests of the government. She has obtained facts and records with regard to the subjudiced matters and has applied her mind to ensure appropriate and timely feedback to the government advocates. And these are the cases that she is looking over. Then the next Special Lordship.
Anyway, this is something which they feel they should have a legal consultant. Correct. If the prison department has it, why not the other departments? Isn't it?
Yes.
Every
fact-
department would be benefited if they have a legal consultant in their own departments.
In fact,
Like the
Lordship,
petitioner.
I have said it in my affidavit in reply that the police department, they have converted one post of DSP as a legal officer and appointed the incumbent
On
as
regular basis,
on regular basis. Lordship.
not contract.
No, on regular basis. And also, one post of junior engineer in PWD department was converted into a legal officer post. On regular basis, the campaign was appointed. And in the present case, there is already a sanction post, Lordship. In the present case, there is already a sanction post.
Correct. There's a sanction post, but the question is how to fill it up. They have asked you to occupy that post on contract basis, extending it from time to time. And now another issue has been brought up by them, saying that because of this office memorandum, we cannot regularize your service. Now, what is this office memorandum? This is the criteria for how an employee who is employed on contract basis can be regularized.
Yes, yes.
Perhaps that is the thing. But the court has said that this is not as per the constitution scheme, and it is in violation of the Uma Devi's case. So appeal was filed, appellate court has also upheld it. So that is the thing they have. So how do you circumvent this? At best, we can say this post be filled up, since it's a sanction post, government should consider filling up on regular basis.
Lordship,
And
the
petitioner should be given,
Uma Devi case also said that there should be a one-time entitlement for those who have served for more than 10 years. And here there is already a sanction post. So her appointment cannot be termed as illegal, but irregular.
sanction post came later on, na? You were appointed as legal consultant. Sanction post has come as legal officer.
Legal officers.
So upon sanctioning this post, they should have filled it up through open advertisement. You could have been one of the applicants. Considering your past experience, everything, they could have given you the benefit. But they chose not to, just to give appointment on contract
Yes,
basis.
Lordship.
Yes.
Yes, Your Lordship. My only submission is that what enforceable legal right that the state has been violated in this matter? Because under 226 of the Constitution, as Your Lordship is well aware, there has to be some enforceable legal right which has been violated by the state. Here, it's very apparent there is no violation of the enforceable legal right of the petitioner. Lordship, you see the brayer of the petitioner in the writ petition. Writ petition, page 13. Page 13, the prayer of the petitioner in this writ petition. The second para, may I read it, Lordship? To direct the respondents to regularize the service of the petitioner on the basis of length of service, and also since the post was graded duly on the basis of the recommendation of the Department of Prisons to accommodate the petitioner, as the petitioner has attained all eligible criteria as per the Model Prisons Manual. So
Why have you not filled up this
Lordship,
post on regular basis?
Your Lordship, you are well aware of the case of the Oma TV.
No, forget Uma Devi for the time being. I'm asking you why you have not filled up this post on regular basis. Proposal was there for creation of one post of legal officer. Cabinet has approved it. So post is sanctioned and pay scale also prescribed. But you prefer to appoint somebody on contract basis only for 6 months.
No. Lordship, it is not like that. Please come to page 3, para 18 of state counter. Page 3, para 18.
Yes.
That with regard to para 29. May I read it, Lord?
Yes, read.
That with regard to para 29, on 24/9/2014, the Cabinet is meeting approved the proposal of Home Department for creation of a post of legal officer under the Prison Department on the condition that the appointment made to the post would be on contract, in similar with the appointment of standing counsels of the government in the Supreme Court. So it is under proposal it was granted. And Lordship, kindly come to page 4. Page 4, next page. Para 26. Para 26, Your Lordship.
Yes.
May I read?
Yes.
That with regard to the statement made in para 37 of the writ petition, the Cabinet member for regularization of the service in respect of a ceremony so-and-so was submitted on 6/7/2018. In this matter, the Cabinet in its meeting on 18/10/2019 has discussed the matter and directed the Home Department to seek the views and comments of Justice and Law and Personal and Administrative Reforms Department. Views and comments of ANR, Operation and Method Branch, and Justice and Law Department can be sent below. Lordship, these are the comments made by the Law Department. 1. Justice and Law Department. The file endorsed by the Home Department. Home Branch for legal advice for regularization of contract service in respect of Srimati so-and-so legal officer under DIG prison has been examined by the Law Department. it is observed that the Honorable High Court in WBC 145 has ruled that the state should not legalize the service of any person who has been serving on contract ad hoc basis in terms of Office Memorandum 11/8/2016 and Office Memorandum dated 4/8/2008 and declared those memorandum unconstitutional for not being in conformity with the judicial pronouncement of the Honorable Supreme Court in Umativi case. The said judgment and order passed by the learned single judge has been appealed by the learned division bench and read appeal number 16 key of 2019. This being the decision of the High Court orders dated 3/8/2018 and 07/02/2019. Any steps taken would be at variance with the decision of the court and is liable to attract contempt proceeding. Lordship, that is the finding of the law department.
Yes, Mr. Gauhati has read that already. It
And
is
Lordship, that is why I'm saying prayer of the petitioner is for regularization. The limited prayer in this petition is for regularization, nothing else. So when the very office memorandum passing on which the petitioner was supposed to be regularized has been set aside, quashed by this very honorable High Court in view of the Umativi case, we as the enforceable right of the petitioner here, Your Lordship.
Now, where is the document to support your paragraph 18?
Your Lordship, I have the writ appeal.
No, not writ appeal. Writ appeal I've understood. Uma Devi and all that. Now, at paragraph 18, you're saying that the cabinet has approved that this post is created only to be filled up by contract basis. Where is that document? On the other hand, petitioners annexure 11 at page 32, sanction of the post. This does not indicate anywhere that it is to be filled up on contract basis.
For that aspect of the matter, Your Lordship, I agree. It was created for contract only, not for regular.
No,
So your
you agree
petitioner
or
was
you
showing
don't
an-
agree is one thing. I want to see the document because your affidavit says that it was created only for contract basis because that is how the cabinet approved it. But this notification of 11 November doesn't say that at page 32. Non-plan expenditure, pay scale, so and so, everything is there. Concurrence of finance. Because there is no document annexed against paragraph 18 of your counter affidavit.
No. Yes, Your Lordship, even though it has been created. The
Have you
limited-
understood what I'm trying to say? See, post is created.
Lordship.
Then petitioner says that if post is created, appoint me regularly. But you are saying that post is created, but only to be filled up on contract basis. That is how the cabinet has approved it.
That is how.
Correct.
Because
So where is the approval? Where is the approval of the cabinet?
Lordship, embargo has been imposed for regularization by the Umativi case, Your Lordship.
No, we are not on regularization now.
Limited period of the petition is.
Okay, I'm not on regularization. I'm on the contract basis thing which you have highlighted in your affidavit. We are not regularizing him because there is a bar. That is one thing. But you're also saying that the creation of post is solely with the understanding that post will be filled up on contract basis. But where is that document? Page 32 is not like that. Simply post is created. Do you have a copy of the cabinet memo,
No, Your Lordship.
cabinet meeting minutes?
No, I don't have that, Your Lordship. But
Normally that agenda is there, isn't it? Items, then they say approved, approved.
whatever it is, whatever it is.
So that should indicate,
I admit page 32, Your Lordship, that it has been graded. I admit page 32 as a document. I admit page 32 of the writ petition. But the fact is that the case of the petitioner is for regularization of her service. That is the only issue. there. I admit that. Page 32, I admit.
but then why did you make this statement here? Paragraph 14, 18.
No, it was a decision, Your Lordship, and then views are there. Because I admit it was been serving since 2009. And whatever the case is, now petitioner is on contract. The limited prayer of the petitioner, Your Lordship, is for regularization of this writ petition. How can
See, now petitioner may pray for regularization, court may not grant it. But now it has come to light that you have created the post.
Lordship?
So what is the idea behind creating that post? You say that it is only to be filled up by contract basis, but it is not there in the post-sanction order. So you have to indicate that. If it's not like, if it is as it is in page 32, then you should fill it up on regular basis by considering whoever is eligible, including the petitioner.
Lordship, please come to page 33. The next page.
That's the appointment order
Yes.
on contract basis.
Yes. Because of this 32 page. This has come.
So you produce the records, we'll see. Because you have also said here in your affidavit in opposition at page 5, prison department themselves, they are asking for contract
That is what?
posts. So we have given them contract posts. Why they are now saying that it should be filled up on regular basis? Isn't it? Home Department, Home Branch itself was specific in the proposal placed before the cabinet for appointment of so-and-so on contract against the proposed post of legal officer. Page number 76C of the file. This is what you have quoted. Let us see the records and see.
Lordship, the petitioner is on contract and he is seeking for regularization. That is a limited prayer in this petition. So how, under what basis he is seeking for regularization? So this is the only question, Lordship, in my limited understanding of the writ petition.
No, we are not limited to that prayer only. See, she may pray for regularization, but the larger picture now is that there is now a post. How is that post to be filled up? Whether you will continue on contract appointment till she attains 60 years, or do you tend to fill it up properly by selection and appointing somebody who is qualified? That has to be seen, Your Lordship. And you have saying that the purpose of creating the post was because we want to fill it up only on contract basis. But this is not available in that particular document. So I would like you to produce the records. I'll make it clear, Lordship. Next, please write, by filing this writ petition, the petitioner, who claims to have been appointed as legal consultant since the year 2009, seeks her regularization to the post of legal officer, which was created by notification dated 11/11/2014, within bracket annexure 11. To stop. According to the petitioner, despite creation of the post, she has only been appointed on contract basis, white notification dated 12/11/2014, within bracket annexure 12. Next para. The state respondents have filed their counter affidavit, and at paragraph 18 of the affidavit, it is stated that the cabinet in its meeting held on 24/9/2014 approved the proposal of the Home Department for creation of post of legal officer under the prison department on condition that the appointment made to the post would be on contract. Similar to the appointment of standing counsels for the government of Nagaland in the Supreme Court. Stop. The post creation notification dated 11/11/2014, however, does not indicate this aspect. Full stop. Next para. The state respondents in their affidavit at paragraph number 26, within bracket Roman 1 small, has also stated that the Home Department, bracket open, Home Branch, close bracket, itself with specific was specific in the proposal placed before the cabinet for appointment of the petitioner on contract against the proposed post of legal officer. To stop accordingly, the petitioner was appointed as such. To stop. Considering the above step and having regard to the fact that there are no supporting documents available on record, the learned senior government advocate, Mr. Muaim Chen, shall produce the relevant records supporting the statements at paragraph number 18 and paragraph number 26, within bracket Roman 1 small, of the affidavit in position on the next date. List the matter again. Honorship after 2 weeks.
2 weeks.
Today is 29th. 20 April, 20th April,
Lordship.
24, 2023.
Published, Lordship.
Yes.
Item number 8.
May it please, my lord. My lord, I've been informed that the respondent number 1 has retired, lordship. So I may be allowed to file appropriate application to implement the incumbent principal director, lordship.
What was the direction?
The direction was to consider the case of the petitioner if found eligible within a period of 2 months
For what?
for appointment
Compassionate
on
appointment,
compassionate grounds, lordship, as per the scheme, lordship.
Lordship, I was appearing for the incumbent, the previous incumbent, Lordship. What has happened is, we have sent to the government for approval. Government has already approved the appointment, but there's no vacancy. So we are put up to the government for the vacancy, Lordship. And as soon as the vacancy arises,
You filed that.
yes, Lordship. But
I see that you have not filed it. You have not filed the process.
Yes, lordship.
yes, Lordship. I'll be filing the affidavit. Lordship.
See, if the process is on,
Yes,
instead of verbally saying that active consideration as highlighted in the
yes,
various
yes,
orders,
Lordship.
you show that by filing an affidavit.
Yes, Lordship.
It has to be placed on record.
Otherwise, how do we believe you?
Yes, Lordship. Lordship, I'll be filing. But since the
Like Thomas, seeing is believing.
Lordship,
Lordship.
Lordship, since the incumbent.
So, when will you file?
Lordship, after the implementation of the new incumbent, Lordship, because the principal director is already
The
retired.
first incumbent expired.
Expired,
Second incumbent transferred.
retired.
Now third person has
one,
come.
Third person has come, Lordship, yes.
Who is that third person?
Dr. VP Dino Sachi.
Srimati, yes.
Srimati VP Dino.
Can you give that in writing? I'll read now only. Please write down, the learned counsel for the parties submit that the present incumbent. And the incumbent who was holding the post of director,
Principal director, lordship.
principal director, Department of Health and Family Welfare, Nagaland, Kohima. That is Dr. Vikato Kinimi.
Yes,
Kinimi.
Lordship.
Has been transferred,
No,
Retired,
retired.
has retired.
Yes.
And the present incumbent is Dr. So-and-so. You give it to the PS. Yes. Full stop. On the oral prayer of Mr.
Tushi Olong, my lordship.
Toshi Orong. So-and-so. Have I, oh, your name is in the costly list.
Yes, lordship.
Toshio Longkumar.
Yes, lordship.
Dr. So-and-so is implemented as respondent number
3.
1, lordship. Yes. In the
She'll be number 3.
respondent number 2. Because earlier that person was deleted. That
Okay.
is why
Yes.
only one remains. Respondent number 2.
Yes.
Let this remain
Yes, Lordship.
as respondent number 2.
Lordship.
You have instructions?
Yes, Lordship. I have instructed to appear.
Mr. Next para, issue notice to the newly implemented respondent. Returnable by 2 weeks.
Lordship.
Stop. Mr. N. Mozui, learned counsel, submits that he has instructions to appear on behalf of the new incumbent.
Lordship.
Stop. As such, no formal notice is required. Stop. Mr. N. Mozui, learned counsel, further submits that proposal for considering the appointment of the petitioner has been sent to the administrative department,
Lordship, already approved.
and
Proposal,
the
yes.
same was approved.
Yes. Only the vacancy, the post.
Stop. However, since there is no vacancy at the moment, the department is waiting for the vacancy
Lordship.
to occur so as to accommodate the petitioner.
Lordship.
Stop. Considering the submission, the newly implemented respondent should file
Lordship.
the details of the process undertaken
Lordship.
within a period of 2 weeks.
Lordship.
List the matter again after 2 weeks.
Lordship.
Deeply obliged, Lordship.
Obliged, Lordship.
Item number 11.
May please, Your Lordship, Lordship, I may be allowed to take you to page 10 of the contempt petition. This is the page 10. This is the order dated 9/12/2020. The page 10. The following direction that the respondent should consider and dispose of the representation of the petitioner dated 18/6/2020 within a period of 2 months from the date a copy of this order is received. Further, the respondents are also directed to consider the prayer of the petitioner in this petition in regard to payment of her area of PA from 4/9/2019 while considering her representation. Then, Your Lordship, my affidavit, page 5. Page 5, this is the letter dated.
How many respondents are there?
Lordship, there are 5 respondents.
And this affidavit is filed by?
Filed by respondent, Lordship. Respondent number 3.
Number 3.
Yes, Lordship.
Who is he?
Lordship, she is the, she has not been implemented as a party, but she was the present chief, engineer-in-chief. So, Lordship, at page 5. This is a letter dated.
She's the engineer-in-chief.
Yes, Lordship.
She's not a party to the contempt petition.
Because the earlier engineer-in-chief retired.
Retired.
Yes, so she is.
So she on her own has given this
Yes.
status of the
Yes,
case.
Lordship, yes.
Okay.
So, Lordship, at page 5, by letter dated 8 July 2021, the department has intimated to the petitioner regarding about the examination of her representation. I may be allowed to read, Your Lordship. In reference to the above cited subject and as directed by the Honorable High Court dated 9/12/2020 passed in WPC, such Srimati Longboy versus State of Nagaland and others.
Ms. Shukre, I've read it.
Yes.
Now, what
Yes.
are those discrepancies?
So, Your Lordship, the discrepancy is at page 6. The type copy is at page 7. The name of the petitioner in PIMS and others are different. Her date of birth in PIMS and others are different. Her father's name in PIMS and others are different. And we have asked
Okay,
her.
this is addressed to her.
Yes, Your
Yes, so
Lordship.
tell me, what have you done?
Your Lordship, I'm appearing on behalf of Miss Atai.
Where is she?
She's indisposed.
You're not in this case?
Yes, Your Lordship.
See, you are supposed to give some explanation here. They say that there's some discrepancies. So this rectification is required. Communication is already given to the petitioner. So what is the response of the petitioner that we have to know? When can she come?
Tomorrow.
When?
Then, Your Lordship, pass over for the day, Your Lordship.
She's he or she? Emathai?
She.
She.
Your
Indisposed?
Lordship, she is out of station.
Okay, when she come back?
Then Lordship make it on 25th of April or 24th of April.
All right. Please write down. This contempt petition is filed by the petitioner alleging willful and deliberate violation of the court's order dated 9/12/2020, passed in WPC number 197 of 2020. This representation was for regularization, is it?
Yes, Your Lordship.
Stop. By the said direction, comma, the respondent authority concerned was directed to consider the representation dated 18/6/2020 of the petitioner within a period of 2 months, and also to consider prayer for payment of area pay with effect from 4/9/2019. Stop. Since the same has not been done according to the petitioner, she has filed the contempt petition. Next para, the engineer-in-chief, NPWD, no, before that, after the, you just add the present incumbent holding the post of engineer-in-chief, NPWD, although not impleaded as a respondent, has filed an affidavit.
Lordship, now she is not the present incumbent anymore.
Okay.
Yes, she has taken voluntary retirement, Your Lordship. Yes, Lordship, and she contested the recent election. So
And
the
lost.
present, yes, but
And
at the-
lost.
Lordship.
What election? Assembly.
Yes, Lordship.
And lost.
Yes.
Then you cancel that, the present incumbent. Engineer Kahuli Sema, although not a respondent, by virtue of holding the post of engineer-in-chief, NPWD, at the relevant time, has filed an affidavit on 21/2023, wherein it is stated that there were some discrepancies found in the service records of the petitioner, and for that reason, a representation could not be processed as directed by this court. So the petitioner also was informed to make necessary rectifications / clarifications by communication dated 3/10/2022. And without which the order of the court cannot be complied with. Full stop. To answer what has transpired pursuant to the communication dated 3/10/2022, the learned counsel for the petitioner, Ms. M. Athai, is reported to be out of station. So, in view of above, the matter is adjourned for the day, to be listed again on
Either Lordship, 24th or 25th, Lordship.
24th of April.
Lordship, much obliged.
Please inform.
Yes, Your Lordship.
She should be ready with what has happened, okay? And if she has not replied back, let her reply back in the meantime, the petitioner, I mean,
Yes, Your Lordship.
so that we can close the matter. Yes.
Item number 12.
Lordship.
Yes.
This is pertaining to non-release of the contractor bill, Lordship. A writ petition was filed, a direction was given to the.
Where is the direction?
Lordship, may I kindly come to page 8. Lecture 1 of the contempt petition, Lordship. The operative part, Lordship, will find it at page 10. Last paragraph. Taking into consideration of the facts and circumstances of the case and submission of both the legal counsel, the writ petition is disposed of with the direction that the respondent should consider payment of the pending bills claimed by the petitioner for execution of the work given in the work order issued by the chief engineer, police engineering project, Nagaland within a period of 3 months from today, but also after proper verification of the work claimed to have been executed. Now, this is judgment dated 27/10/2021. In spite of the lapse of the time bound, Lordship, they have not made a payment to me. In the writ petition, we have annexed the completion certificate issued by the competent authority, whereby it has been clearly stated that I have duly executed the work as per the specification. Now, Lordship, during the pendency of the contempt petition, a new DGP has appointed Lordship, and we have implemented him.
Who's the petitioner? Petitioner is the contractor.
Contractor, Lordship.
Some work was completed.
Completed.
Money not given.
Money is not given.
So, new DGP has been implemented.
Yes, Lordship.
And
on 20 February 2022.
and chief engineer also.
Yes, we have implemented the chief engineer and
5 and 6.
Yes.
So notice is complete?
Completed, Lordship.
Who's appearing? Are you appearing, Mr. TB Jamil?
Not for the new incumbent, Your Lordship. I'm yet to receive any instruction.
I see.
Whether notice has been completed or not, office note with this thing.
Steps has been taken, Lordship, on 28th February 2022. Respondent number 6.
Only respondent number 6.
5 already completed, Lordship.
6 DGP.
Yes.
5 is complete.
Yes, Lordship.
I am appearing, Your Lordship.
Oh, appearing for 5.
I am appearing.
Yes, what is the instruction?
But for the newly implemented. Now, Your Lordship, here. We are not denying regarding the liability, Your Lordship. Payment is complete. In fact, work is completed. And in fact, this is not the only case, Your Lordship. There are other, this matter relates to a police engineering project. There are other several works were executed where the pending bills are there. And in fact, some other contempt matter also pending, Your Lordship. So what the department is doing is Lordship, department is trying to pay in installment, Your Lordship. In fact, here, the amount shown is 72,50,000, something, Your Lordship. Page 9.
So why don't you put that in paper?
Lordship.
So that
Now,
we understand.
In fact, in Lordship, in installment we are paying. In fact, this financial year efforts are being made to clear all the dues, Your Lordship. So I may be given 2 weeks time, Your Lordship. I'll file affidavit.
Lordship, the issue is this. I've been allotted the work, Lordship, because the money was there.
Mr. Mozui, this is not a writ petition. This is a contempt petition.
Yes,
we cannot go in. I mean, we should not hear the matter in detail. Only thing is that order has been complied or not. If not complied, why? That much.
Yes, sir.
Just,
so let him
2 weeks.
Let the respondent number 5
and 6.
5 file the thing. 6, so there is no return service, isn't it? Till now.
No.
You can very well take Mr. Jamir.
In fact, Your Lordship, respondent number 5 is only the executive engine of the project. The money will be sanctioned by, like DGP is the main, Your Lordship, PHQ.
Not executive engineer, chief engineer.
Sorry, the chief engineer. Like, he is not the sanctioning authority so far as the money is concerned.
Yes,
But
Mr. Angami, why don't you inform the DGP about the case pending here? They should engage somebody.
Lordship, information can be given, Your Lordship.
Please give information
Lordship.
through your good office
Lordship.
that this is a thing pending. You should appoint somebody
Lordship.
to represent you. Otherwise, court will take it otherwise.
So, and
because already more than 1 month, there's no representation.
And Your Lordship, I think I can file affidavit for respondent number 2, Your Lordship.
2 also?
2.
2 and 5?
2, if
who is 2?
2 is the Home Commissioner, Your Lordship. Because 5 affidavit, he is only chief engineer. He will not be sanctioning the amount, Your Lordship, except for saying
No,
overseeing.
that's okay. He may not sanction, but he can say that
Yes.
I'm not the authority.
Lordship.
But on my part, I have done whatever I can.
Lordship.
These are the authorities. He can say that.
Lordship.
And it should not be a combined affidavit.
Lordship. I've understood.
Separate affidavit.
Understood.
Because this is by name, by person.
Understood, Your Lordship.
So, Mr. TB Jamir, learned counsel for the petition number 2 and 5. Praise foreign is granted 2 weeks' time to file show cause reply of the said respondents. Mr. N. Angami, learned state counsel, is also requested to inform the respondent number 6, that is the Director General of Police, Nagaland, about the pendency of this contempt petition. Since there is no representation, despite the fact that notice was already issued
on 20th February.
On 21/2/2023. List the matter again after 2 weeks.
Lordship.
Much obliged.
Obliged, Lordship.
Item number 16.
16.
My lord, just 5 minutes late. Can you start?
So you can complete within 5 minutes.
My lord, if your lordship, yesterday your lordship has pointed out about the annexure 2 of the writ petition.
Annexure 2.
Yes. The extension was up to December. That is 4th July, April 2021. That is why I've stated it, para 5.1 of my additional affidavit, page 5. Oh, page 5 is this honorable court by order dated 21/6/2022 directed it is noticed that the petitioner has been engaged as night tutor and the facts be by order dated such and such. And his service has been extended from time to time. The last order, this direction was passed on 1404, that is annexure 2 in the writ petition, wherein the period of his service extension is from 31/12/2021 to 30/12/2022. As such, the respondent shall not oust the petitioner from service in view of the order dated such and such. To 5.1, how it was passed by your lordship. At this honorable court order dated 21/6/2022 was passed under the given situation that there was still an existing order for continuation of petitioner service till 30/12/2022. What happened is that, my lord, the petitioner, that is my additional affidavit, page 12, annexure 19. I prayed for extension of service, which was submitted on 17/11/2022. However, what happened is that private respondent issued one legal notice stating about the pendency of this honorable court proceeding. May I read out, my lord?
Who's for the respondent?
Respondent number 5, my learned friend is.
I'm appearing for respondent number 5, Lordship.
5.
Yes.
Private respondent.
Yes, Lordship.
Yours, there's a stay order.
This is stay order, Lordship.
And government? What is your submission?
Your lordship, with regard this, to the additional affidavit, your lordship.
Yes, additional affidavit, this thing that saying that in view of the notice, this thing,
Your lordship, here, in my humble submission, your lordship, the order dated 14/4/2021.
come to the additional affidavit. Do you have a copy?
The additional affidavit?
Yes.
Yes, your lordship.
Come to the last page. Director has extended till disposal of the writ petition. So what is there to pass in this court? Any order to be passed from this court? Because his tenure was up till 30/12/2022.
Yes,
correct?
your lordship.
But in view of the legal notice, director also has applied his mind. He said, no, we'll extend because court case is pending. So let it be extended. What is there? And we fix the matter for admission hearing some other day.
Yes, your lordship.
This only for that purpose, I think you have filed this additional affidavit.
My lord, because the petitioner is still continuing, he is the lone night tutor in the establishment.
You continue, no problem. Nobody is stopping you.
My lord,
Director is also allowing you.
My lord, yes, I understand.
Until we dispose of the thing, let you continue. So
That is what my prayer before your lordship is that. Because
So-
it is keep withhold. It is, your lordship is saying that page 14.
Yes.
Therefore, further extension of his service is keep withhold till disposal of the writ petition by the honorable court.
What does it mean?
That means my extension will not be given. Further extension of his service is keep withhold, my lord. That is what. So there is no extension order.
Okay.
That is the whole thing, my lord.
Otherwise, what is the stage of this writ petition? It can be heard, isn't it?
My lord, private respondent was given on 28. No, 16/3. 3
What?
weeks to file affidavit in opposition. 16/3. 2023.
Yes, Mr. Mwajamir, have you filed?
Lordship, if this matter can be listed after a week for admission hearing, in the meantime, if I may be allowed to file reply, Lordship, only on one aspect of Lordship.
Okay, we'll come back at 2.
My lord.
Then we'll pass the order that time.
So, my lord, my limited prayer is to direct the respondent authority not to host the petitioner till disposal of the petition. Of course, your lordship is saying that it is keeping with toll only. It is not a termination. Particularly, I may be allowed to take your lordship to para 12 of my additional affidavit. This is how the petitioner is running the house. The eldest one completed metric exam. Second one in class 10. Third in class 5. Fourth in class 2.
It's okay. I've understood your case.
My lord, much obliged.
Please write down. By filing this writ petition, the petitioner has challenged the impugn office letter dated 14/4/2022, by which administrative approval for appointment of private respondent number 5, correct? Was given. To a Group D post in the Directorate of Science and Technology. So the petitioner claims that he has been working as night chowkidar on contingency basis with effect from 1/4/2011, and instead of regularizing his service, the respondent number 5 has been approved for appointment in his place. Stop. This court White order dated 21/6/2022. In view of the order passed by the Director of Science and Technology on 14/4/2021, directed that the petitioner should not be ousted from service during the extended period with effect from 31/12/2021 to 30/12/2022. Full stop. Next para. Thereafter, White order dated 11/11/2022. The appointment order of the private respondent number 5 dated 20/4/2022 was stayed by this court. Stop. Since the extension of the petitioner's service was only up to 30/12/2022, and that the writ petition is yet to be disposed. The petitioner has filed an additional affidavit on 23/3/2023 with a prayer that he should not be ousted from his service, that is the post of night chokidar. Under the Directorate of Science and Technology, Kohima, Nagaland, till disposal of the writ petition. Are you still working, Mr. MT? Stop. The learned counsel for the petitioner, Mr. MT Longchar, MT Longchar, submits that the petitioner is working as night chokidar as on date, although the extended period was only up till 30/12/2022. To stop, he submits that the petitioner, through his legal counsel, had served a legal notice.
My lord, that is respondent number 5.
Oh, this is by the
Respondent number 5.
Okay.
Lordship, sorry for indulgence, Lordship. If I may be allowed to make a submission with regard to notice, Lordship.
Yes.
It was made known to the present council, Lordship, only when the additional affidavit was filed, Lordship. It appears that the legal notice has been served by a different council, however, with the knowledge of the present petitioner.
Anyway, I'll not mention it then. I thought it was by the petitioner.
That is why I also did not hammer on that.
Stop. Next, but at this stage, Mr. Mua Jamil, learned counsel for the respondent number 5, submits that he may be given how much time?
A week's time.
A week's time to file the affidavit in opposition of the respondent number 5. Stop. Next para, considering the above position and the submission made by the learned counsels for the parties, it is hereby directed that the petitioner should not be ousted from his post till the final disposal of the writ petition. Mr. Mo Jamil, learned counsel, is also granted a week's time to file counter affidavit of respondent number 5. List the matter again. After 2 weeks. 2 weeks.
For admission, hearing,
for admission.
Much obliged.
Yes.
Orders, item number 18.
This is that case. What have you found?
Your Lordship.
Yes.
May kindly go to the date order was in 1/3/2017.
1/3. Yes, I got it.
Your Lordship, there the counsel for the respondent sought for 2 months time to comply with the order. And then thereafter on 2/5/17, the respondent placed a copy of the Honorable Supreme Court order dated 17/4/17.
Who placed it?
The respondent.
I see.
Yeah. Which state the operating order passed in 1/3/17. The Supreme Court state the order passed in 1/3/17. Reorder.
Place a copy of the order of Supreme Court staying the operation of order and the conduct. list the matter again after receiving copy of the order of the Supreme Court. So what does it mean, this order? Because council has already produced the copy of the order,
Yes,
correct?
Lordship. Yes, Lordship.
But then court says that list the matter again after receiving copy of the order of the Supreme Court.
Yes, Lordship. Thereafter, on 17/4, Lordship, sorry, 2/5/17, the respondent placed the order passed by the Honorable Supreme Court on 17, which was on passed on 17/4/17. It's already flagged, Your Lordship.
Oh, this has come from the Supreme Court.
Yes, Lordship.
So before that, council had produced a copy of the order.
Yes, Lordship.
So now what is the status of this order, of this Supreme Court case?
Your Lordship, since I'm no longer with my senior, therefore I have no information regarding the
And who is your senior?
S. Dada.
What is your good name?
My name Asnla.
Asanla.
Yes, Lordship.
What is this? Zevi Su.
She was also appearing on behalf of my senior, but since now she is a government in government sector, so she has left it.
Ms. Datta's name is not there, otherwise. He's a senior counsel.
Yes, Lordship.
And today you want to withdraw?
Yes, Lordship. To delete my name, Your Lordship. Just
Of course, to delete your name.
Yeah, Your Lordship.
And who has filed this Bakalatnama?
Lordship.
Yes, Datta is there. Your name is there. Then one more is there. ASGI. None of the names, oh, okay. Kamei Alin Rongmei. P. Suren. Who are these? Do they come to the court?
Lordship.
The former SGI.
No.
In the cost list, the name is there. Kamei Alin Rongmei.
I believe it has been changed, Lordship.
So who are the petitioners here?
The petitioner is the Longsa village.
What is the address? Just like that.
It's represented by the chairman of the village council, Kongan Mern.
Let us see where's the petition. Longsa village. What about Mr. Datta? You're not with him anymore.
Yes, Lordship. I'm not with you.
But his name is still there, isn't it? He's still the council, isn't it?
Yes, Lordship.
Are you in touch with him, Mr. Datta?
Not much, Lordship.
Okay.
I can inform him, Your Lordship.
Yes, you must inform him. Please write down Miss Asenla Walin, Learned Counsel, submits that her name may be withdrawn from the list of arrayed counsels for the petitioner, since she is no longer with Mr. S. Datta, Learned Senior Counsel, who appears for the petitioner in the matter. Stop. It is also seen that against the order dated 1/3/2017, passed in the present contempt petition, the respondents have approached the Supreme Court of India by filing SLP within brackets C numbers 11595/2017. And the Supreme Court, by order dated 17/4/2017, while issuing notice to the respondent, had stayed the operation of the order dated 1/3/2017. Stop. It is not known as to what has happened to the SLP before the Supreme Court, since no one appears for the respondents today. To stop. At the same time, since Ms. Asenla Walling, Learned Counsel, has submitted that she's no longer with Mr. S. Datta, Learned Senior Counsel. Next para, in view of above, name of Ms. Asenla Walling be deleted from the arrayed counsel for the petitioner. To stop. At the same time, Ms. Asenla Walling is requested to inform Mr. S. Datta about this order, so that the petitioner is represented in the next court date. Stop. Registry is also directed to check up with the latest order passed by the Supreme Court in the above noted SLP and put up a note. List the matter again. When shall we have it? On 24/2023.
Much obliged.
Please inform him, huh?
Yes, Lordship.
Item number 19. Item number 19.
Make appeal. Aye.
Maybe Lordship.
You are the applicant.
Appellant, Lordship.
Appellant.
Lordship, as per order dated 9/12/2022, we have taken steps.
In what? IA or the in the?
In both the IA and the make appeal.
What is this IA for?
For stay, Lordship.
Stay.
Lordship.
Now, has the appeal been admitted?
No, Lordship.
Then, so where's the question of taking steps in the IA then? Appeal has to be admitted first. Then all the question of stay will come. Is there any delay in filing the IA, appeal?
Lordship, there has been condoned, Lordship.
Already condoned. Notice is gone to whom? How many respondents are there?
There are 11 respondents.
How did you take steps? Registered post?
Registered post, Lordship, in both the IA as well as the MEC. It's forwarded dated 9/12/2022.
And notice was issued on 16/12.
Lordship. Taken steps on 15th in the registry must have taken
11 respondents.
Lordship. But Lordship here, the respondents 1 to 9 are represented by the respondent 1. The respondent 2 to 9.
Who are they? Children?
Children, Lordship.
Then 10 is owner of the motor vehicle. And 11 is also the driver.
11 is the driver, Lordship. 10 is the owner.
What kind of accident happened? Tell us. You have deposited 25,000?
Yes, Lordship.
So what is the case about? Mr. Fosico?
Lordship, here the case is that the deceased was traveling in a gypsy. And
This is a common judgment award.
yes, common judgment, Lordship.
28, 29, 30 MAC appeal, MSC case. Why?
Lordship,
They're all related or what? Or
the other occupants have also filed the claim petitions.
what, is
They're either injured.
what are the facts of the case?
Here, the injured, the deceased was traveling in gypsy and had a collision with the truck, a bus. And the White Nitong Pom, he died, Lordship. Succumbed they were coming from Longland.
Occupant of the gypsy died?
Yes, occupant.
Occupant of the gypsy died?
Yes, Lord.
And who are the claimants?
The claimant is the husband, the father, wife, and his siblings.
Father, what about husband?
No.
Well, how can it be wife? Wife died, isn't it?
Son died.
Son died.
Yes, Lord.
Then parents have claimed.
Parents along with the other siblings of the
They've
deceased.
claimed. And
Yes,
who are
claimed.
they here? From respondent number 1 to
1 to 9,
1 to 9.
Lordship.
1 is the
Father, Lordship.
father. What about the mother?
That is from 2.
Number 2.
Yes.
And the other are the siblings.
Siblings of the deceased.
They are the occupants of the
No, they were not the occupants.
They are the family of the deceased. Deceased was traveling the gypsy.
Lordship.
And it collided with the truck.
Yes. Bus.
Bus.
Public service bus.
Okay.
Public service vehicle.
And the liability has been fixed on whom? On the bus.
On the bus itself. Whereas the claimant has not fixed liability on the vehicle they were traveling.
Then what about all these different cases, 3 cases clubbed together?
There are other occupants of the gypsy.
How many occupants were there?
Lordship, Altogether, there are.
They also died.
No, Lordship. Some are injured, Lordship.
How many person died? One.
Lordship, that other cases, I'll have to explain, Lordship.
So how come you file only one appeal? You are supposed to file 3 appeals.
I have filed, Lordship. I have
Where are
filed.
they?
There are other connected cases, but today only this matter has come up, Lordship.
What are those other connected cases? Tell me. Do you have the number? MSc appeal numbers, what?
Lordship, I don't have that.
Can you provide later on?
Lordship, I can do that, Lordship.
You provide it to Ms. Chasi here.
Lordship.
How many cases you have filed? How many appeals you have filed? 3.
3, Lordship.
So what has happened in those cases? Delay.
4, Lordship.
4 cases.
Lordship.
Delay condoned.
Delay condoned.
And notice has gone.
Lordship.
Like this.
Lordship.
In fact, notice should have been issued in the main appeal. In the IA, they have always passed. This is not the correct thing. So,
in other cases, the Honorable Court was pleased to stay the operation of the MCT and on the subject, on the condition that the claimant, the insurance company deposit a certain amount of
how much? 50%?
50%, 30%, Lordship.
We'll see that. We let it be listed along with those cases. You provide the numbers.
Lordship.
Please write down. This is an appeal filed by the insurance company against the common judgment and order dated 23/1/2020, passed by the Motor Accident Claims Tribunal, Dimapur, Nagaland, in MSC case numbers 28, 29, and 30 of 2014. There are only 3 cases. So how do you say that there are 4 appeals? Mr. Foseko? What is that one extra appeal?
Lordship's right. 28, 930 only. 28, 930 of 14.
By order dated 9/12/2022, notice was issued both in the appeal as well as in the interlocutory application for stay of the impugned judgment and order. And the appellant was asked to cancel that, and the appellant not required. Stop. The appellant took steps and notice was sent to the respondents on 16/12/2022. Does not even indicate how it was taken.
Lordship, registered AD.
That is what you're saying. It's not in writing here anyway.
Lordship.
That is why. The order also is not there, and the note also is not there. However, office note dated 19/12/2022 indicates that return service report is awaited. Next para, Mr. Fosiko Fote, Learned Counsel for the appellant, submits that the present appeal is filed against the which case? MSc?
MSc 30 of 2014.
MSC case number 30 of 2014, and that separate appeals have been filed for MSC case number 28 and 29 of 2014. Next, para in view of above, list the matter again. After a week, when?
On 10th, Lordship, 10 April.
On 10th of April 2023, along with MSC appeal numbers dash and dash of 2021.
Not 21.
Please give the number, okay?
Lordship, I'll do that. Vice, my Lord.
Item number 21.
21.
May I please, Your Lordship?
Yes.
Lordship, this IA is for on donation of delay of 149 days. Lordship, I have made some mistakes in this petition, so kindly allow me to rectify the number of days.
What mistake?
The number of days.
How many days should it be?
Lordship, it should be 107 days, but I have written 149 days.
That's okay. Even the registry should compute the days. Instead of accepting whatever you stated, they should also compute this is the number of days. Although so-and-so has given this much days, but on computation, we find that this is number of days. That should be there in the file. But it's not there. Anyway. So that is one thing. Then what about the other things? Notice?
Notice has been issued, Your Lordship.
No, I mean, has they received it?
No,
It's
no,
not
Lordship.
complete.
No, within
You
this-
are?
for the respondent, respondent one.
You did not receive, but you are here today.
Lordship,
How did you know that?
Lordship, I have sent notice by registered post with a lead.
You are for the insurance company,
Yes, Your Lordship.
National Insurance.
Yes, Your Lordship.
And you appear for which respondent?
Respondent number one.
One,
Yes, Lordship.
Niva Das.
Yes,
And what about the others? Are they all related?
No, Your Lordship.
Tarun Das.
No. Number one and two are related, and then respondent number three is owner cum driver.
How are they related?
Respondent number one is the wife of the deceased, and the respondent number two is the daughter.
No. How can it be daughter? It's Sri Tarun Das. He's a male, not female.
Son.
Son. Wife and son of the deceased.
Yes, Your Lordship.
And Sri is the owner.
Yes, owner cum driver of the motor vehicle.
So you are appearing for the wife, but not for the son.
Lordship, I'm not aware of. Respondent number one and two are con-
Huh?
Only for one. I was
How-
given instruction.
By
for
whom?
respondent one.
By whom?
My senior,
Where is he? Who's your senior?
Tompok Pongener. He's not here.
Where is he?
He's out of station.
Out of station.
Yes, sir.
Have you filed your power?
No, not yet.
When will you file the power?
Lordship, I'm not aware.
Oh. Please write down, this is an application for condonation of delay of 149 days in filing the connected appeal against the judgment and order dated 31/5/2022 passed by the learned member, Motor Accident Claims Tribunal, Mohokchung, Nagaland, in MSC case number 9 of 2020. Stop notice was issued on 15/12/2022 and person to which, Miss, your name?
Vicky Henyo.
VK
Henyo.
Enyo. Learned Counsel appears and submits that Mr. Tongpok
Pongener.
Pongener will be appearing for respondent number one. Stop. It is, however, submitted by the learned counsel for the applicant, Miss.
Tia Kriller.
Have you got it? Thay Krille.
Yes, Your Lordship.
That the respondent number 1 and 2 are the wife and son of the deceased. Stop. As such, Mr. Tompok Pongener should obtain appropriate instructions from the respondent number 1 as to whether he will be appearing for respondent number 2 as well. Mr. As prayed for how much time to file the power?
Lordship, 1 week.
1 week time is granted to Mr. Tompok Pongener to file his power. Next para. Learned counsel for the applicant also submits that the number of days delay written as 149 in the application is only due to miscalculation, and that the exact number of days delay is 107 days. Stop. The submission made will be considered as and when the application is taken up for disposal. Then what about the 3? No, 3 remains. What is to be done with 3? Borguri Gaon. Where is this?
Assam.
Assam.
Yes, Lord.
Addresses like that, you see, will it reach?
Address. Lordship,
Benu Gopal, son of Koshwal Dutta, resident of Borguri Gaon. That much only.
Yes.
Can it reach? And I'm sure you'll say that this is what was given in the tribunal. Liability has been fastened on the insurance company,
Yes, Lord.
not on the owner, isn't it?
Yes, Lordship.
Okay, so that's why he will not come. This is the matter again after 2 weeks. Objections, if any, to the application for condonation of delay be filed by then. Yes.
For hearing, item number 20, 25 and 26.
This is the last item, is it?
Yes, Lordship.
What is this matter?
Lordship, here, the petitioner said.
Complicated matter.
No, not Lordship. It's a simple matter.
Simple matter.
Lordship, the WBC 215 may be taken up first. There are 2 writ petition, Lordship.
215.
Yes, Lordship.
What is the difference?
Lordship, it's connected only.
215, of course, is filed earlier.
Yes, Lordship.
Yes.
Yes, sir. Lordship, become the page number 51, annexure H.
51 of the writ petition.
Of the writ petition, Lordship.
Yes.
This is an order passed by the Luta Huhu, a memorandum passed by Luta Huhu. The translated copy is at page number 53. Since page number 51, this was passed in their own dialect, Lordship.
I see.
The translated copy is at page number 53.
53.
53.
This is challenged over.
No, Lordship. Lordship, this is under consideration by the State Government.
Yes, what is this memorandum?
Just Luta Huhu memorandum, dated 18 March 2022. Lordship.
Yes.
Luta Huhu passed resolution for Luta Baptist Churches Association and Uka Dom Baptist Church WDC. Lordship. The resolutions are adopted basing on the power vested upon the tribal Uhus by Article 371A, Clause so of the Constitution of India and 16-point agreement so. Since this memorandum was passed in excess of power conferred under Article 371A of the Constitution of India and 16 point of agreement, Worship, the LBC, this memorandum was passed against the LBC, dissolving the LBC. The main issue is, so LBC submitted a complaint to the Deputy Commissioner Oka.
No, just a minute. What is this Article 371A?
Worship, a special provision in respect of the state of Nagaland.
Let's see. Twenty 371A, then subclause A. No act of parliament in respect of religious practice in Nagaland. Shall apply the state. Unless the assembly by resolution decides. Okay. So where does it empower the whole?
Lordship, exactly. But Lordship, this issue, since it is under consideration by the state government now, the state government has to take a decision on this.
Well, that is another aspect, you see.
That is another aspect, Lordship.
See, now it says that resolution is adopted on the basis of the powers given by this.
Yes, Lordship.
So if we read that 371A, it says that no act of parliament or something like that can be.
Lordship, it is only an enabling power. Article 371.
Will not apply unless the state assembly adopts
Yes,
it.
yes, Lordship.
So this happens in other states also. So, but where is the power to make such kind of memorandum?
No, Lordship. There's
And
no
what is the
power.
memorandum about?
Lordship, the memorandum is solely regarding the dissolution of the LBC.
Dissolution of the
LBC, the petitioner, Luther Baptist Churches Association.
petitioner.
Yes, Lordship, the
I see
petitioner.
the petition, the LPs. LB,
LBC, in short, Lordship, Luther Baptist Churches Association.
LBCA.
Lordship.
Okay.
Lordship is a short order only, so let me read the entire order, Lordship.
Yes.
According to the observation of Lagdalhu, the tribal body, there is discontent in the administration of LBC, due to which there is likely to be division in LBC. Division is likely to be costly for the Lutas. Therefore, in order not to have any division within the Luta tribes and to have unity for the betterment of the tribe, the following resolutions are adopted. WTBC, this is a provision of Uka Tom Baptist Church. WTBC, the linking from LBC be reviewed and provision be set aside to readmit the church whenever the situation is conducive. Number
What WTBC was dealing toward?
Lordship, it happened like this. Lordship, the cracks of the issue, Lordship, it happened like this. Lordship, I'm allowed to take 5 minutes on this.
Sure,
issue.
sure.
Lordship, 3 fellowship churches under the Oka Tom Baptist churches. They were asking for independent status. That means they want to function separately from the mother church. WTC is the mother church.
Okay.
So 3 churches under its under this WDC, they were asking for independent status. Lordship, this WDPC, in its general meeting, they have also resolved that the independent status will be granted after the celebration of their Centennial Jubilee. Thereafter, Centennial Jubilee was celebrated. After the celebration of Centennial Jubilee, also independent status was not given to the 3 independent churches.
Okay.
So they approached the LBC.
They approached the
LBC, Luther
LBC.
Baptist, yeah, the present petitioner.
I see.
Since recognition has to be given by Luther Baptist Church Association, by this LBC.
And what happened? And what happened then?
Thereafter, Lordship, the LBC, they have conducted a committee to ascertain whether the 3 churches they are entitled to be given the independent status. That was conducted. Thereafter, during the process, there was between the 3 independent churches, some of the believers, they want to remain along with the WTPC. Somebody they wants to go for they want to go independent. So that issue came up. Deputy Commissioner Oka issued an instruction dividing the churches into 2 services. That means morning service and the evening service. Those believers who wants to be along with the WTPC, with the mother church, they have to worship separately. And who wants to have independent status, they have to separate independent, and another timing for them. That was challenged by the WTPC. before this honorable court.
See, those three churches were all worshipping in one common church.
Lordship, like this. WTB is a mother church.
Correct.
Under
Mother
this
church.
mother church, those are the fellowship churches.
Three fellowship churches.
Three fellowship churches.
So worship is done on those three fellowship churches.
Yes, Lordship.
And those persons who are worshipping those three separate churches, they also come to the mother church.
Lordship, that also give me Lordship. But in the present case, in the three fellowship churches, Deputy Commissioner Oka has directed to have two timings to worship.
Correct.
So WDBC, the Oka Tom Baptist Church, they have approached this honorable court by filing a writ petition. And the writ petition was during the pendency of the writ petition.
Challenging the order of the Deputy Commissioner.
Deputy Commissioner.
Okay.
Dividing the church into two services.
Then?
During the pendency of the writ petition, the petitioner, Lota Baptist, the present petitioner, they have given the independent recognition to the three churches. So after the writ petition was disposed of on the since they have given the independent status, so as agreed upon by the parties, both the councils.
Petitioner is authorized to give such recognition.
Yes, Lordship.
That you are independent church now.
Yes, Lordship. Since all the churches under the Oka district, it has to be affiliated to the petitioner, to the LPC.
I see. So in that line, it was disposed of.
On that line, it was disposed of. But the one issue arises again during that time.
Yes.
While disposing of the writ petition, this honorable court has directed the Deputy Commissioner of Oka to hand over the keys of the churches to the three independent churches. Accordingly, the keys was handed over to the three independent churches.
So this three independent church cannot function without the permission of the
for independent recognition. For
WTBC.
WTBC, since the three independent churches are under WTBC, WTBC has to give the no objection for its to go independent.
I see. So that recognition is not sufficient.
Recognition is not sufficient unless this WTBC give the recognition.
Okay.
Yes.
So matter was not resolved then.
Matter was not resolved.
Matter was not resolved, even though you say that you have given recognition.
Yes,
matter is not resolved unless the WTBC gives that
Yes,
recognition.
Yes, sir.
And court directed that you give the keys to the church to the
court
three.
has directed the Deputy Commissioner since there was a dispute. The keys was the churches of the keys of the churches was also with the Deputy Commissioner Oka.
I see.
That issue also came up before this honorable court. This honorable court directed the Deputy Commissioner to hand over the keys of to the three independent churches.
Okay.
In compliance to the order passed by this honorable court, the keys was handed over to the three independent churches. However, again, this WTPC, again, they have submitted an application to the Deputy Commissioner saying that you have handed over the keys of the churches to the three independent churches by misinterpreting this court order.
Misinterpreting.
Yes, Lordship. So thereafter, again, the Deputy Commissioner tried to seize the keys from the three independent churches. There, the law and order situation became worse. So the three churches, he approached his honorable court by filing a review petition.
Review petition. Okay.
Bring before this honorable court to clarify about the keys. So when the matter was thus subdued, the Lota Hoho, he summoned the present petitioner to settle the issue. Since this Lota Hoho is a tribal body and the LPC is a religious institution, religious body, the petitioner refused to attend the meeting called by the Lota Hoho on this 18 March 2022. And on that day, this imbued resolution was passed.
What about that review petition?
Review petition,
It's still pending?
No, it's disposed of. No.
How it was disposed?
This honorable court disposed of the review petition by permitting the parties to approach the appropriate forum to settle about the assets.
Appropriate forum.
Yes, to approach the civil court. Receive the copy, the order passed by the in the review petition. Receive on last occasion I placed before this court. It will be a copy of the order will be. Order dated 24/2/2023. Justice is Serdo on the verge of his retirement. He passed the order.
What exactly was sought to be reviewed?
Receive
Giving the keys.
exactly to interpret the receive
Interpret.
the order passed in the writ petition. Receive I've annexed in the present writ petition also. Receive page number 43.
43.
43.
43.
Receive the relevant portion is at page 46. The second bar, Receive, in view of the submission. In view of the submission of the learned counsel in the development that are stated to have been taken place, this court is of the view that no purpose would be served by keeping the writ petition pending. Therefore, it is disposed of with the direction to the Deputy Commissioner, Oka, to hand over the keys of the churches to the respective functionaries, so that the parties may be able to worship in their respective church building and start functioning independently.
Okay, so it was just to open the door. Now, what about the properties? Where did the question arise? Property of between assets and all that, as directed in this review, you may approach the civil court. But who is fighting for the property? The mother church and the three church?
Yes, Lordship. Since the three fellowship churches, it was constructed well the three under the supervision of the mother church.
Okay.
It was it was with the mother church, the three fellowship churches. So
I see.
they have constructed it jointly.
No, if they have constructed three churches, is it not independent?
No.
Please,
They are
Your
fellowship.
Lordship,
Lordship.
I may be allowed to give a little submission in this aspect.
Yes.
I am also representing the respondent number 5,
Who is that?
the LBCR. I am the respondent number 5 in this case, in this prison writ petition. CR, Lota Baptist
Reformist
Church,
Corporation. They are reformists.
Reformist. Yes. So here, what I would like to imagine this honorable court is that what my friend is giving a submission now is not related with this prison writ petition, which is before this honorable court. It is totally a separate case, and the prison writ petition is only with the state respondents and LPCR. They have implemented me as party and the LPC, and it is not connected with this submission that my learned friend is.
Okay, I understand, but the thing, he was giving me a brief background.
Yes,
I
that's
wanted to know the background because
All right.
without knowing the background, it's difficult.
Even me, Lordship, I have not started the main issue, which is the work. I'm just giving the cracks of the
So review was disposed like that.
Yes, Lordship.
And now this writ petition has been filed to challenge.
Lordship, I'm challenging the an order issued by the Registrar of Society, summoning the LBC to conduct a trial of strength. No convenience motion.
Now, what about this memorandum?
Lordship, yes. Lordship, this memorandum is under consideration before the state government. That I'll come for that
Consideration by the state government.
Lordship, against this memorandum.
No,
we have-
what has been
Yes, Lordship.
decided by this memorandum?
Yes, Lordship. Lordship, since Lordship, I'll take your Lordship only the relevant paragraphs. Lordship, may come to paragraph 5.
5.
Yes,
Yes.
In order to reorganize LDC, Luta who hereby elect interim administration. That is, the interim period of the 5 main posts of LDC shall be for a period of 6 months. That is 1, pro tem president, pro tem vice president, pro tem executive secretary, pro tem secretary, pro tem joint secretary. To initiate for election of new LBC office bearers the following senior servants of CATS are authorized for 6 months. Reverend Dr. Swin Su, that is not relevant. The last paragraph at the bottom. The above named at para 5P shall discuss and designate the posts among themselves in report to Luta Huhu. And Luta Huhu shall approve consent to begin the work. To reorganize LBC, LBC shall be under interim administration for 6 months. During the interim period, the constitution of LBC shall not be strictly followed, but strive to work for reorganization, seeking the will of God to lead the Luta to the right path. The Brudim named at para 5P shall elect all required position 51 as per LBC Constitution in accordance with their person to the right post, provided that the interim members shall not be selected from among the existing office bearers members. After the interim period of 6 months, the 5 Brudim deem may either elect LBC President, Executive Secretary, Vice President, Secretary, and Joint Secretary, and hand over charge to them or be considered in their position to function for the next full term as per the Constitution of LBC. 1 month period is set for executing this organizational work. The present LBC administration, office bearers, and executive body is hereby dissolved. This is more important, para 6. By this memorandum, they have dissolved the existing LBC administration.
Existing LBC is dissolved.
Yeah,
And in that place, they have directed that
That an interim body has been formed.
how long will that interim body continue?
It has to be as per this memorandum for 6 months.
Then after 6 months, what will happen?
Here is in this memorandum, nothing has been mentioned about it.
And the interim body will be elected by whom? These persons named
By this
here.
person, that's right.
How is the election to be held? From members?
From members.
Members of the congregation.
Member,
They will vote.
Members of the affiliated churches.
Affiliated churches. Okay. So this memorandum was issued like that. You did not participate in this.
For not participating in the meeting and considering the issue between the 3 churches in the Okatom Baptist Church, this memorandum was issued. From the first paragraph also, it's very clear.
Yes, then?
Yes, Worship, against the action of the Luta Huhu, Worship, we have submitted a representation, Worship, that is page 56.
Yes.
To the Deputy Commissioner. Worship, I are allowed to read only the relevant motion. Worship,
Yes.
Para 3.
Para 3.
That the Luta Baptist Church Association, being a registered association, under the Registration of Societies Act 1950, as amended by Registration number so and so, White Government Registration number so and so, dated 3/5/1986. The LBC has our own constitution memorandum of association duly approved by the government. Hence, any change in the LBC setup can only be effected by resolution of the LBC Executive Committee and delegates. In the event of any dispute and or dissolution of the society, it can only be arbitrated by the appropriate authority empowered by law, and no civil society organization can interfere in its issue. That is against the action of the Luta Huhu.
Okay.
In our prayer, para it.
Yes.
In the matter as prayed.
I've read it. Now, can the deputy commissioner do that?
No.
Is he empowered?
No. Rightly, the deputy commissioner has referred the matter to the commissioner.
Okay, where? By which letter?
By
58.
Page 58.
58?
Yes, page 58. In inviting a reference to the subject cited above, I am to inform you that this office have received a letter from Luta Baptist Churches Association requesting to vacate the ticket of Luta Huhu, dissolving the Luta Baptist Churches Association executive body, citing that banning of LBC activity and dissolving its executive body by the Luta is without any legal basis versus Article 371E and 16.8 agreement. Here in Deputy Commissioner has rightly pointed out. Since the memorandum was issued in excess of Article 371 and 16 point agreement, Lordship, the Deputy Commissioner has rightly
No,
referred to
it
the-
is not the deputy commissioner. It is you who have pointed out.
No, Lordship, this is the letter of the Deputy Commissioner, page 58.
No, the office has received a letter from the Lotha Baptist Church Association
Yes, Lordship, yes, Lordship, yes, Lordship.
to vacate the diktat of
Yes.
the Ho-Ho,
Yes, Lordship.
citing that it is there's nothing in the Article 371. So
Empowering the tribal
he is simply conveying what you said.
Yes, yes, Lordship.
It is not the deputy commissioner who has decided that
Yes, yes.
it is against.
Yes, yes.
372.
In accordance with my presentation, Lordship.
Yes. Now what happened after that? Commissioner has done what?
Yes, Lordship, may kindly see the next paragraph.
The
Before
next.
appropriate authority may kindly examine the matter and give necessary direction
Yes.
as at the earliest, considering the sensitivity and urgency of the case. Usually, as I've submitted, there was law and order situation within the district. So the deputy commissioner has again issued an appeal.
Appeal. Yes.
Lordship.
Appeal is there.
Yes, that is. Lordship, may come to page 60. This is very important.
Appeal has been accepted by everyone or it's violated.
Lordship, it has been accepted. Since
Okay.
immediately after the dissolution of LBC, the LBCR, the private respondent, they were planning for installation. That has been stopped by this. Lordship.
Respond number 5.
Yes, Lordship, respondent 5. Lordship, may come
Then
to
60.
Page 60. Lordship, I've annexed a type copy, but page 60 is also legible.
The
only.
commissioner has again in turn written to the home commissioner.
Home Commissioner. Lordship. Since Lordship since the Commissioner Nagaland is only a directorate, the appropriate authority is the Home Commission, the state government. Lordship, shall I read the entire letter or only the relevant?
No, not required.
Lordship, may come to the entire case, page number 61. The second last paragraph, Lordship.
What is this legal adjudication pending before the High Court?
Lordship,
Which
regarding,
case?
regarding the pendency of the review petition.
Review petition disposed of.
No, Lordship, before the disposal of the review petition.
Correct. Now it's already disposed of.
Yes, Lordship. Now, yes, another thing has come.
What is the date of disposal?
It was disposed of on
24/2. 24/2. And now this letter was 6/4/2022. Okay, right.
Lordship, may I take Lordship to the relevant portion,
Yes.
page 61, the second last paragraph.
Yes.
This office.
Yes.
This office is of the opinion that the ordinance memorandum dated so and so issued by the Lota Huo should be considered null and void, since it is ultra-virus and also in the predicts that legal adjudication is pending before this honorable court. Before the honorable court. The instant case of the Lota Huo in dissolving the existing LBC administration in reconsidering a separate pro dem interim LBC administration on its own violation at this juncture, that amounts to interference in the court proceedings and may be considered as obstruction in the administration of justice in put established law under bad light. However, it is suggested that the MBCC may be requested to make an attempt in resolving the impasse as per the direction of the Honorable High Court. Moreover, it would also be prudent to solicit the view and comments of the Justice and Law Department to enable the government in taking a well-informed decision. The last paragraph is important. This is for favor of your kind information and necessary directives, please.
What is NBCC?
NBCC and Nagaland Baptist Church Council. Again, Lordship, LBC is again affiliated to NBCC.
NBCC, okay.
Lordship, the state government, after receiving the letter from the Commissioner Nagaland,
So what is the sum and substance of this letter?
Lordship, the sum and substance of this regarding the letter of the Commissioner Nagaland, Lordship. Lordship, as per the view of the Commissioner Nagaland, the action of the Lota Huho, he expressed that it should be considered null and void.
Okay. Then,
And has referred to the state government for further necessary directives. He has not taken any decision.
okay.
No decision has been taken by the Commissioner Nagaland.
He has mentioned about the High Court. Then he also mentioned about NBCC.
Yes, Lordship. MBCC for Lordship to suggest may you requested to make an attempt in resolving the impasse
Okay.
to come as a negotiator.
Then
Should we come to page number 64?
64.
64. Your Worship, the main contents of the writ petition is the impugned order issued by the Registrar of Society is in violation of this law.
Impugn?
The impugned order, which has been issued by the Registrar of Society,
Okay.
summoning for calling for a no confidence motion, is in violation of the letter issued by the State Government. That is a main contents in the writ petition.
Okay, we have not come to that
Not come,
yet, isn't
no,
it?
no,
We have
no.
not come to that
Worship,
yet.
I want to take your Lordship to Sireli
Yes. Now, this letter has been issued by the Deputy Secretary
by the Worship, Deputy
pursuant to the letter of the Commissioner.
Commissioner. Worship.
What is this?
Worship, I read from the beginning. I'm directed to refer to your letter number so and so, dated 6 April 2022, which just which we have written now. On the subject cited above, in doing submit that the matter has been examined, and it is found that the grounds which have been given for dissolving the Lutha Baptist Church Association administration and replacing it with an interim administration by the Lutha Huhu by its memorandum dated so and so has its genesis primarily on the issues disputes concerning the control and administration of certain churches in Oka district, the legal adjudication of which is pending before the Honorable High Court.
That is that review.
That review.
Okay.
Now, already dismissed. The aforesaid steps taken by the Lutha Huhu and consequent action, if any, at this juncture could be construed as interference in the court proceedings and also considered as obstruction in the administration of justice. In view of the above,
Yes.
all concerned parties may be advised to maintain status quo as it existed prior to 18 March 2023. 18 March 2023 is the day when the Lutha Huhu dissolved the LPC. Till the pending matter is disposed of by the Honorable High Court or fresh directions are given by it.
Okay.
So, since the matter is pending before the Honorable High Court, Worship, the state government has directed all the concerned parties to maintain the status quo as it existed prior to 18 March. Now the matter has been, the pending matter before this court has been already disposed of. Worship. However, the state government has not taken any action on the memorandum issued by the Lutha.
On the memorandum issued.
Memorandum issued by the Lutha.
Okay.
Since the memorandum issued by the Lutha is subsidized before the state government, so that is not challenged before this court.
So government also say that High Court is seized with the matter, so you all maintain status quo.
Yes, maintain status quo.
But the matter is already disposed of.
Now already disposed of.
Now it's entirely up to the government.
Now it's entirely about the state government to pass a decision on the action of the Lutha.
Okay.
The aggrieved party is at liberty to approach to challenge that decision of the state government.
That is one aspect. The other aspect is regarding cancellation of your registration.
Not cancelled so far. Lordship, it happened like this.
No, you are saying that some
no confidence motion.
No confidence motion.
Lordship,
Yes.
I'll come to that.
Where is that?
Lordship, I'll come to that. Lordship, and several restraining or prohibitive orders were issued concerning the law and order situation. And on the basis of the prohibitive orders issued by the district magistrate Oka, the petitioner is functioning in his office. Yes, Lordship, we come to page number 70.
Page number?
70.
70.
Lordship, after the dissolution of the petitioner by the Lutha Huhu was using the Luku in the nomenclature of the LPC.
What do you mean?
The Luku in the nomenclature of the LPC was illegally used by Lutha Huhu.
In which? In the memorandum?
No, Lordship, the writing bit or the logo of the, since the Lutha Huhu, they have a separate logo.
They have a separate logo, okay.
Yes,
Then?
and that has been utilized by the Lutha Huhu.
Okay.
So we have submitted this complaint letter on 28/3/2022 to the Registrar of Societies, page number 70. Subject, Lordship, complaint against...
No, what is that regarding logo? Logo you're saying? What is the relevance of that logo? Why are you saying that?
Lordship, since The Lutahu Public Charges nomenclature in Luku. Lordship is mentioned in the subject. Complaint against unauthorized and illegal use and or use of Luta Baptist Churches Association nomenclature in Luku by Luta Uhu and request for appropriate action thereof.
So where have they misused it?
Lordship, since after they dissolved the LBC, now the power has been assumed by this interim body.
Okay.
This interim body has been constituted by Luta Uhu.
In view of that memorandum.
Yes, in view of, thereafter all the nomenclature that Luku, it has been used by Luta Uhu.
Existing body was dissolved and new body has been created.
New body has been formed.
So that's why you're saying that they're misusing your logo.
They are misusing my property. So we have submitted this complaint.
I see. Yes.
Thereafter, page number 72.
72. What is your prayer otherwise in this page 70?
Lordship, page 70, Lordship, to show that the complaint has
To
been
kindly
submitted.
examine the matter and initiate appropriate action against Lota Ho
Yes, Lordship.
and parties involved in the unauthorized illegal use and misuse.
Yes, Lordship.
Okay. This was on 28/3.
28/3. We were dissolved on 18/3 and we have submitted after 10 days, Lordship.
But by the time the government letters come, isn't it?
No. Lordship.
Status quo.
Government letter came very lately, Lordship. It came on 6, it came only on.
It came after this only.
Lordship, government letter came only on 10/6/2022.
Correct. So it came after you approached the
Registrar Society.
registrar.
Yes, Lordship.
What did the registrar do?
Since Lordship, the LBC is registered before the Registrar of Society. It needs the since I'm registered before this authority, I've submitted the complaint seeking for appropriate direction. Accordingly, Lordship, we come to page number 72. Thereafter, this Registrar of Society has issued this notice, summoning the petitioner as well as respondent number 5. Whereas the Lota Public Service Association, here called as the association, is a registered society under Society Registration Act 1860, and therefore bound by the provision of the Act. Whereas multiple representation and complaints by the members of the association has been received by the Registrar of the Societies, herein after called the Registrar, concerning disputes between two groups of association members with regard to election of the office bearers. The Registrar, as per this letter, we have not raised about the selection or election. Now, therefore, both the groups are hereby required to appear before the Registrar on following date and time in the office of the Registrar in the Home Department. The parties are also hereby directed to bring their written submission along with all evidence proof in respect of their submission. Group A, which has represented itself as Lota Public Churches Association, RCC. That is our respondent number 5. Reformists, initially, after the Lota who constituted this respondent number 5, they were called RCC.
What's the full form?
Reformist Core Committee.
Reformist Core Committee.
Again, now they have changed it to LBCR. That means LBCR Reformists.
Okay.
He is directed to appear before the Registrar on 16 August 2022 at 10:30 a.m. in the office of the Registrar, come additional secretary. Home Department Civil Secretariat at Kohima. The group may present itself in the form of delegation of not more than 3 members. B, which has represented itself as Lota Public Churches Association, is directed to appear before the Registrar on 17 August 2022 at 11:30 a.m. in the office of the Registrar, come additional secretary, Home Department Civil Secretariat at Kohima. The group may also present itself in the form of delegation of not more than 3 members. This notice is served under Section 3, read with Section 23 of the Act. In the case of non-compliance of the notice by any of the parties, the Registrar will pass ex parte order. This notice is issued on this day, 10 of August 2022.
So separate date has been
Separate
given.
date has been given.
Then?
In compliance to the notice issued by the registrar, Lordship, on 5/9/2022, Lordship, page number 73. Lordship, we have submitted the following documents. Original Memorandum of Association of LPC constituted at the time of registration, latest amended Constitution of LPC, and latest amended Constitution of LPC translated in English. Thereafter, Lordship, the ambient order was issued by the Registrar of Society.
This page 73 is by the petitioner.
By the petitioner, Lordship.
By the petitioner.
Yes, Lordship.
Then the impugn order?
Lordship, the ambient order is at page number 74.
Okay. Passed by the registrar.
Registrar of Society. The main substance of the order is summoning for a special general conference to test the confidence motion introduced by the present LPC office. Shall I read the entire order or?
I think it's not required. What is the operative motion? What does it say?
Yes, Lordship. Therefore, Lordship, we come to para 11. Page 77.
Yes.
Therefore, I hereby direct that a special general conference of all the delegates in terms of the MOU shall be called to assemble on 11th of October 2022 at the Mission Center, Wangusang, Oka, in order to test the confidence enjoyed by the current office bearers of the LPC and select the office bearers in accordance with the MOU. MBCC is requested to depute one of its representatives as observer to the general conference, Sri Ki Suensu. ATC headquarters, Oka, shall also be an observer to the general conference. The observers will ensure the orderly conduct of the general conference in accordance with the MOE and certify the result of it. Further, the list of office bearers selected, along with updated rules with latest amendment, shall be filed with the Registrar of Societies within 14 days of the general conference in compliance of Section 4 of the Society Registration Act 1860.
Yes.
So, Lordship, by this impugn order, the general conference was called on 11 October 2022. Again, he has issued again another, we have submitted a representation against this, saying that it's not called for. Again, should we come to page
It is
number?
not?
Yes, Lordship. The presentation submitted by the petitioner is at page
Stating
number
that?
79. Page 79.
What is your objection about?
Lordship, our objection, Lordship,
See, there's a reference to the MOA,
MOA. It's just the
Memorandum of Association.
It's just LPC is a registered association with the MOA.
Okay, what does it say, MOA?
MOA says to receive the election, the selection of the office bearers, it has to be done only in the general conference.
So that is what the registrar had done.
He cannot convene the general conference. And Lordship, the issue is, Lordship, the action of the LUTA who dissolving the LPC is under consideration before the state government. State government has accordingly issued a status.
That is one aspect.
Status
Regarding HOHO's action, that is examined by the government. Now, at the same time, the registrar is also said that you prove your confidence motion by holding a assembly. And this is in terms of the MOA.
What, Lordship, when the action of the, if the action of the LUTA who dissolving the LPC, that is set aside by the state government. In that case, the LBC, again it will revive. But when such action when the state government has not decided any on that issue.
So
again,
what is to be done then?
Lordship, my submission is, Lordship, as per the letter dated 10/6/2022, issued by the state
So the
government.
matter be adjourned till the such time that the decision is taken by the government.
That can be done, Lordship.
What is there for this court to decide in this writ petition?
Lordship, the reason for not taking any action, Lordship, as per this letter dated 10/6/2022, the status quo, the direction, the status quo direction issued by the state government.
Correct.
Since the matter is pending before the High Court.
So why don't you file an application to the government saying that this order directed was basically on because of the pendency of the review petition. Review petition, isn't it?
Review petition.
Review petition has been disposed of. So nothing stops from the government to decide now. Please decide. That can be done.
That option also. In this honorable court also can dispose of this writ petition.
How to dispose of this writ petition?
Since, as per this letter, due to the pendency of the review petition, no final decision was taken by the state government. Now the review petition has been disposed of. The state government can be directed to take a decision on the action of the Luto.
That will be subject to what additional AG has to say and the other state. Otherwise, what is the challenge here?
The challenge is the Lordship is calling for no confidence motions.
No confidence motion. So what happened ultimately? Was it held?
No. Lordship, this honorable court by an interim order has suspended this impugned order.
Has suspended this order?
Yes, Lordship.
I see.
Order dated 18/10/2022.
Twenty.
18/10/2022.
Oh, 1810.
Yes.
Shall stay suspended till the next returnable date.
Lordship, that has been extended from time to time.
So this has continued till now.
Yes, Lordship.
So this is stay of 39.
Lordship, there is another order, impugned order. Lordship, by the order dated 39/2022, the General Conference was fixed on 11 October 2022. Again, the Registrar Society has issued another order dated 7 October 2022. This is page number 83.
October 1st. Then
By this order, Lordship, page number 83, again, he has refixed the date of to 21st October 2022.
why?
Lordship, in the first order, there's no modalities laid down in what manner the no confidence motion has to be conducted.
Okay.
So by this 7 October 2022 order, he has framed certain modalities and he has refixed the date on 21st October 2022.
So the interim order passed by this court was dated 1810. But that order has not been stayed, isn't it?
Lordship, no. Lordship,
Only 39
31, Lordship.
39 has been stayed.
Yes, Lordship, the main one.
Then what about 710? There's no mention.
It's not mentioned, Lordship. Lordship, my submission is when the matter is not dissolving the LBC, when it is under consideration before the state government, the registrar of society, he cannot take another action in order to resolve the issue. If the state government decision comes in my favor,
Under what provision is the state government to look into the matter? Otherwise,
Lordship, nothing has been mentioned. Only
is there
the,
any provision?
no, Lordship.
Because DC could not do anything except for law and
DC as well as the Commission Nagaland cannot do anything in this matter.
DC is basically for law and order.
Since the
Commissioner is again another directorate
He's
and
not a
who is
directorate.
to look into the, what is the main function of a commissioner?
Lordship, commissioner is a supervisory authority of the deputy commissioners only. He's a directorate only. Any decision has to be taken only by the state government. He also has to only forward the matter to the state government. The state final decision has to be taken only by the state government in every issue. And as per his leader also, he is seeking for necessary directives.
Sorry?
In the leader of the commissioner, he is also seeking for necessary directives from the state government. If you see,
Commissioner.
yes, Lordship, if you see page number 61, in the bottom.
So the state has filed their affidavit here?
Yes, Lordship.
What do they say?
Lordship says that they are just justifying the action of the registrar of society. They have not stated anything about whether any action has been, whether any decision has been taken on the basis of this letter issued by the Commissioner Nagaland.
The Lotha Baptist Church Association is a registered association
Yes, Lordship.
under the Registrar of
Registrar of Society.
Firms and Societies. So if anything is to be altered of the association,
The general body has to take a decision, and that has to be submitted to the registrar of society. Since the association registered before the registrar.
no, that is there, but now here is a group, another group has come up because of the whole.
Worship, yes. That issue has been I've raised in the second read petition.
Second petition is about?
The second read petition, Worship. Worship, the issue involved in this case is, Worship, as per the calendar of events of the LBC, these are yearly events we have to follow. We have convened a delegate conference. After we notified about the conference, the respondent number 5, they have also convened another conference, a parallel conference, same delegate conference. We submitted a representation to the Deputy Commissioner Oka, requesting to desist the respondent number 5 from conducting the said delegate conference in view of the status quo direction passed by the state government. Since the status quo direction has to be implemented by the Deputy Commissioner Oka only. Since he failed to exercise his duty, we approach this number court by filing the next writ petition. Here we're raising the issue that, Lordship, the status quo direction was directed to be maintained as it existed prior to 18/3/2022. Lordship, if we interpret this status quo order, Lordship, on 18/3/2022, the LPC was in existence.
Was in existence.
It was dissolved by Lutha Ho only on this day. And
So that is why that particular date has been given.
yes, Lordship. And respondent number 5 was not in existence on this 18/3/2022. It came to its existence only on 18/3/2022 due to the action of the Lutha Ho dissolving the ill-present petitioner and considering the respondent number 5. So we are saying that in view of the, by interpretation of this status quo order issued by the state government, respondent number 5 is a non-existing body. That is our condition in the next writ petition. However, the Deputy Commissioner Oka, for the reason best known to him, Worship,
No, you have submitted representation.
we have submitted a representation. That was not
That-
considered.
Not considered.
That
That's
was
why
not
you filed
considered.
this writ
We
petition.
filed this writ petition, Lordship.
Then any interim order here?
Lordship, this honorable court has directed both the parties not to conduct a general conference.
By which order? Okay. 612.
Yes, Lordship. So, Lordship, we have accordingly complied to that. However, Lordship, again, the respondent number 5, thereafter also, again, they are convening some other programs. So, we have filed an additional affidavit in this writ petition, and we have brought on this of this honorable court. This honorable court was of the view that the interim order has to be applied to both the parties. Since in the status quo order, it has been mentioned all concerned parties. So this honorable court was of the view that the status quo order has to be applied to both the parties and has directed both the parties to abstain from conducting the state conference.
That interim order was on 612.
612.
And your affidavit is 21/1 this year.
Yes, Lordship. May I take your Lordship to
Any such mention about your interim?
Lordship may come to page number 10
Of the?
of the additional affidavit. Lordship, the interim order was passed on 6/12. You have convened another conference on page number, Lordship, page number 11, 28 December 2022. And Lordship may come to page number 14. Another program on 28 to 29, 2022, December 2.
All right, there's no such separate order for this, isn't it?
Yes, Lordship. But
Only,
Lordship-
only that one interim order passed in December.
Yes, Lordship. Since the interim order was passed on 6/12/2022, all these programs which have convened is totally in violation of the interim order passed by this group, as well as the status quo order passed by the state commission. That is our case.
That's what you want to project here.
Yes, Lordship.
Now
And
what-
Lordship, one of my condition in this, the next week petition is 299, Lordship, 294, Lordship.
Yes.
Lordship, I'm bringing that the private respondent number 5 should be declared a non-existent body in terms of the status quo order passed by this, passed by the state government. Parties were directed to maintain the status quo as on 18/3/2022.
Yes, you have said that already.
And Lordship, as per the admission in your counter affidavit, after the Lota Oho dissolved the LBC informed them, they have considered the respondent number 5 was constituted only in the month of July 2022. That means even their constitution was done in violation of the status quo order passed by the state government. Status quo order was passed on 6/10 or 10/6.
Any counter affidavit filed in WPC 294?
No, Lordship.
No counter affidavit?
No counter affidavit.
Only in this 215?
Only the main rate petition, 215. And as per their admission in their affidavit, in this 215, they were formed only in the month of July 2022. That was done in violation of the status quo order passed by the state convention. Lordship, we come to the affidavit in the position filed by the respondent number 5, Lordship.
Yes. See, the genesis of this case is that Hoho's decision. correct?
Whose decision?
So, if that is going to be considered by the state, why should we all waste our time here in trying to decide whether registrar should do it or not, all that?
That's why, Lordship, the state government could not take any final decision initially. The state government could not take any final decision for the reason that the review petition was pending.
Correct.
Now the review petition is disposed of. Now there's no obstruction for them.
So let me hear the other side. What do they want to say? Yeah, government.
With this Lordship, Lordship here, the petitioner, the LBCA, it is a registered society under the Society Act. So the provisions of the society applies to them. The issue before this Lordship is that under LBCA, there are 147 constituent churches. So out of 147 churches, 80 churches do not want the present office bureaus to continue. Then only 23 of the churches are in support of the present petitioner, and the rest remain neutral. So now, Your Lordship, the petitioner, because of the internal interest, whatever, the members of the LBCA do not want them to continue, but they want to continue. That is the crux of the case, Your Lordship. So, Your Lordship, when there is a dispute among the members, the Losa Hoho decides the matter. Then the Lota Hoho, they form an pro-interim body, out of which the petitioner make a complaint to
So, question is that can they do it?
No, they cannot do it.
So you decide,
No,
because
so
the
Your
matter is
Lordship-
with the government.
No, Lordship, it's like this. Your Lordship, we had already decided the matter, we had already examined the matter, and we passed an order saying that status quo as on 18/3/2022 should remain.
Let us see that status
Yes,
quo order.
Your Lordship. Sorry. Page 64, Your Lordship. So there is nothing pending before the government. Page 64 of the writ petition.
Till the matter is pending before the High Court is disposed
Lordship,
of.
yes, Lordship, may kindly come to the first para, I may be allowed to read. I am directed to refer to your letter number such and such dated on the subject cited above and to submit that the matter has been examined and it is found that the ground which have been given for dissolving the Lota Baptist Church Association administration and replacing it with an interim administration by the Lota Hoho by its memorandum dated 18 March 2022 has its genesis primarily on issue dispute concerning the control and administration of certain churches in Woka district. The legal adjudication of which is pending before the Honorable High Court, the aforesaid step taken by the Lota Hoho and consequent action, if any, at this juncture could be construed as interference in the court proceeding and also considered as obstruction in the administration of justice. In view of the above, all the concerned parties may be advised to maintain status quo as it existed prior to 18 March 2022 or till the pending matter is disposed by the Honorable High Court or fresh direction are given by it. So, Your Lordship, the matter has been examined and status quo was granted to them. If we take the view that the matter is still pending with the government, Your Lordship, that is only up to the pendency of the review. And the review is already, judgment has already been out. And Your
As far
Lordship-
as High Court is concerned, matter is over.
Yes, it's over. And then
Now, the commissioner has, DC has written to the commissioner. Commissioner has written to the government.
Yes.
Home commissioner.
Yes.
To give directives.
Yes.
And government has said High Court case is pending, so status quo. That
Yes.
much only.
So
High
you-
Court case is no more there. So you have a free hand to decide.
Lordship is like this. Lordship is under Article 25. Your Lordship knows very well that the state cannot interfere into the internal affairs of the religious organization unless there is a morality, health, or public order, Your Lordship.
So you say that
Yes.
by way of speaking order.
So, Your Lordship,
Then the party will take recourse to whatever
then
remedies
the other
available.
issue, Your Lordship, here, one, the petitioner approached the government, the DC. Then the DC in turn make a communication to the government. Then the other issue is that the petitioner, they approached the registrar of the society to take to examine the matter and to take appropriate action. So accordingly, the registrar has gone through all the memorandums of association. So when there is no provision in the memorandums of association as to how to remove the office bearers, Your Lordship, the registrar relying on the Supreme Court judgment. In such a provision, when there is an absence, the registrar can call for a floor test, Your Lordship. So the registrar has called for the confidence test of confidence of motion, and the petitioner is approaching before this court, Your Lordship.
See, regarding that, who should be there, who 80%, 40% want this. Now, what is the provision? These office bearers are basically, how do they come to their respective post?
That's what, Your Lordship, if we read the registrar order, it will make the picture clear. Lordship may come to page 74. This is the registrar order dated 30 September 2022. Page 74 of the writ petition.
Yes.
Yes. Dated 30 September 2022, in view of the ongoing dispute amongst members of Lota Baptist Churches Association, a notice was issued via letter such and such dated August 22 to the current office bearers of LBCA and another group among LBCA going by the name of LBCR, whereby LBCR was directed to appear before the Registrar of Societies on 16/8/2022 and LBCA on 17/8/2022. The dispute among the members of LBCA is regarding the office bearers of the association. The current office bearers of LBCA, as per the representation submitted by LBCA by such and such dated 30/7/22, reflected the following as office bearers: Reverend E. Nrio Izan, President, then number Inchimbo Shiteri, General Secretary, Shukumbe Muri, Vice President, Ramben Ovund, Joint Secretary, Sutuntang Lota, Executive Secretary, LBCA. However, above named have not been furnished to the Registrar of Societies for certification as mandated under Section 4 of the Society Registration Act 1860 as amended in its application to Nagaland, which reads as follows. All these things, Your Lordship, I'll leave. Then page 75, Your Lordship. The LBCA has failed to comply to above stipulation of the Society Registration Act 1860, neither the list of personal governing board member, etc., nor the updated constitution rules of the societies have been filed. In fact, based on the latest renewal of the LBCA registration, via such and such, dated 15/2/2022, in terms of Society Registration Act 4/1860, via Section 3A, Clause 4, following officials have been recorded. Vice President Otum Ben Kikon, Vice President Wonja Monguli, Secretary Ilin Tang Lota, Joint Secretary S. Ransam Kitan, Senior Accountant Ribe Monjami, Mission Secretary LBCA and Peter Sitri, ex-official Reverend Dr. L. Sanso. So, Your Lordship, even the petitioner also, they have different office bearers while they submit to the registrar. The LBCR has submitted through the representation by letter dated nil that a delegates conference was held at Hajan Baptist Church, Samis on 29 July 2022, whereby the present office bearers and executive secretary in charge were removed from the present leadership as there was loss of confidence by majority of the member churches. The LBCAR has also submitted the present leadership has management the affairs of the society. Further, the conference elected the following office bearers. Then number 6, it is evident that there have been several lapses in filing of letters of office bearers and amendment to constitution of the society. This office is hence constrained to look into the representation placed on record by the contesting parties and take further action as per the provision of the Society Registration Act. Section 23 of the Society Registration Act 1860, as amended in its application to Nagaland, empowered the Registrar of Society to pass an order including cancellation of the registration in certain cases. Then, based on the facts which have emerged after studying the representation of both the parties and hearing the submission made by them, it is evident that a large group of members amongst LBCA have expressed their no confidence in the leadership currently holding the position in LBCA. The pertinent question in the extant case, therefore, is regarding the procedure to be adopted in case the society rules are silent with regard to matters of no confidence. It may be mentioned here that a similar case has been dealt with in the Bodan Education Society matter in CN number 412 of 2021 in the Honorable Supreme Court of India. In the case of Swati Ulash Kherkar and other versus Sanjay Wallavalkar and others. The Honorable Supreme Court had reaffirmed the order of the Honorable High Court of Bombay Goa bench in the aforesaid matter, which, while upholding the order passed by the registrar, directing to conduct the election to the various posts in the Sikh society, had relied upon the direction of Honorable Supreme Court in the case of Vipul Bhai M. Chowdhury versus Gujarat Corporation Milk Market Federal Limited in such in Supreme Court of India, and has observed as under. I reckon clinches the issue. In any democratically constituted institution, the office bearers continue to hold the office during the pleasure of the members, and they have chosen those office bearers. Sometimes the governing rules of regulations of that institution are silent about how the governing members must account for the misdeed or maladministration when the tenure is subsisting. In other words, it is institutionally inherent that the governing members must administer the affairs of the institution faithfully, honestly, and diligently. They should always remain accountable to the members for the omission and commission. In the same reckoning, the members' right to unseat these governing members is equally inherent in the scheme of the things, despite no express provision to that effect, says in the bylaws. From the above fact and submission of both the parties, a member of constituent churches of LBCA, it bears out that there is a need for the current office bearers to prove that they have the confidence of the LBCA constituent. The clause 9 and 11 of the original Memorandum of Association submitted by LBCA describe the numbers of delegates to be sent for the General Conference and the valid voting rights. Further, clause 37 of the MOA submitted by LBCA lists out among one of its objectives to assist, cooperate with the Nagaland Baptist Church Council. Therefore, I hereby direct that a special general conference of all the delegates in terms of the MOA shall be called to assemble on 11th of October 2022 at the Mission Center, Vancouver, Wokha, in order to test the confidence enjoyed by the current office bearers of the LBCA and select the office bearers in accordance with the MOA. NBCA is requested to depute one of its representatives as observer to the General Conference, Your Lordship. So then thereafter, the registrar again pass out the impugn order, page 83, order dated 7 October 2022, the modalities as to how the vote of confidence is to be conducted. Page 84, 7 clause C, Your Lordship. Page 84, 7 clause C. Thereafter, ADC Waka will inform all the constituent churches of the Special General Conference on 21st October 2022 at 11 a.m. at Mission Center, Vancouver, Waka, and they will be requested the following: to send the details of the delegates for the conference within 2 days to ADC headquarters. The only question to be decided at the Special General Conference shall be as follows: whether they endorse the current office bearers of LBCA, who are led by Reverend Dr. Ian Rio Ensign as President LBCA, yes or no. If the above is no, then the preferred name of the new office bearers of LBCA. So Your Lordship, is very clear that when there is no provision as to how to remove the office bearers, Your Lordship, when they do not enjoy the confidence of the majority, what the society registrar, Your Lordship, pass an order asking the both the members of the LBCA to prove their confidence, especially the petitioners, Your Lordship. And then with regard to the matters before the government, Your Lordship, there is nothing to decide, Your Lordship. Because what we have stated is that status, we had examined the matter, what the Lota Hotel did was against the law. So status quo as on today, on 18, prior to 18 March 2022 has to be maintained. So according to that status quo, the petitioner is enjoined to be the office bearers. Even if now also, even if we change, bring an order also, that will never change the position of the petitioner, Your Lordship. So it amounts to a futility exercise also, Your Lordship.
See, the only thing is that the order speaks for itself, your status quo order.
Yes,
You have said that status quo as on that date should be maintained.
yes.
That means at that time, the Lota Ho had not taken a decision to form the interim administration.
No, no, no. As on 18.
Yes.
Yes, prior to 18. Yes, yes.
So it as on 18 means without the interim arrangement, correct?
Yes, without the interim.
So whoever the original
So-
association was there remained intact.
Yes, so they are remaining, Your Lordship. They are the petitioner. They are intact.
So they remain intact.
Yes.
And this was directed mainly because, according to the government, the matter is pending for the High Court.
Yes.
And what was pending before the High Court is that review petition
Yes.
to interpret what exactly was the order passed by this court in saying, handing over the keys and all that.
Yes, yes, yes.
But now the court has taken a decision saying that this has to be go to the civil court.
Yes.
So there's no issue pending before this court. So is it not for the government to decide now?
Lordship, in my humble submission.
Or at least speak out that we have no say in this matter, you go to the registrar, whoever it may be.
Because they had already approached.
No, that
the
you have to
registrar.
say that.
And even the we cannot say, Your Lordship.
No,
We
you have
cannot
to
direct them
take a
approach,
decision.
Your Lordship, because the
You have put the gun on the shoulder of the court, saying that court is doing something, we will not do anything.
no, Your Lordship.
Court has done its part. We have considered the review petition and passed the orders.
Your Lordship, I had it.
There's nothing left in the court.
Your Lordship, if we direct the petitioner or the LBC or the opposite party to approach the registrar by the state, would not it be amount to interfering into the affairs?
Interfering to which affairs?
Because they are approaching the registrar for the internal affair management, because the constituent churches, some of the churches, they do not want the
No,
president.
you can very well say that you yourself have approached the registrar, so you solve the problem with the registrar.
So
Government has nothing to decide in this matter.
So, Your Lordship,
So let there be an order like that,
we had
so that the
already
parties
gone.
can seek the remedy.
So now the matter is before the registrar, Your Lordship, and they are challenging the registrar action before this court.
No, that's why you cannot very well pass an order saying that since there's no more dispute left insofar as this thing is concerned before the High Court, except for the challenge of the registrar. Now, it is for the government to decide what to do. And you can ask them, you can approach the registrar. You have already approached the registrar, so you can say that whatever decision is taken to be taken by the registrar on your application to the registrar will have to be accepted by you. If you do not accept, then you have to go for any legal recourse. Because the order itself, status quo order, says that only because of the High Court, we are not taking a decision. It's a very peculiar situation.
So, Your Lordship, my prayer is that, Your Lordship, the writ petition, Your Lordship, the matter is now pending with the registrar. So, registrar has to take a decision on that matter. And regarding with the matter pending with the state government, in my affidavit also, I have stated that the matter ends, and there is nothing in my affidavit also.
What have you
pending.
stated in your
Yes,
affidavit?
Your Lordship. Lordship, page 11 is a continuation of paragraph 16. Page 11, second para. Page 11, second para. Furthermore, there is no matter related to LBCA.
Where?
Page 11. This is the continuation of paragraph 16. Page 11, second para. Furthermore, there is no matter related to LBCA pending with the state government for adjudication, Your Lordship. And even I have stated that also at para 20, page 15. Your Lordship, page 15, that in regard to such and such, the LBC is a registered body under the Society Act and it has to function as per the provision of the Act. The registrar of the society, which the competent authority to adjudicate on the matters concerning society after examining all the facts, has taken certain decision in line with the provision of the Act. Further, as also mentioned in replies to paragraph above, there are no matters related to LBCA, including the action taken by the Lota Hoho in March 2022 regarding it, which are pending with the state government for consideration or adjudication or resolution. Lordship. So that's my prayer.
Your Lordship, may read paragraph 21 also in the affidavit.
No, just a minute. I need some clarification. See, when did you approach? Where's the registrar's letter? 39.
Yes, that is the
2022.
order, yes. But they approached the registrar on 28/3/2022, page 70.
70.
Yes, page 70 is the complaint made to the registrar by the petitioner, dated 28/3/2022.
And that status quo order, where's that?
Status quo order is at
63.
page 64,
64.
10th June, yes. 10
10 June
June
2022.
2022, yes.
Then the impugn order calling them.
Calling them is at page 74.
What is 72? 72.
72 is the notice,
August.
yes, of the registrar asking them to submit all the document in the written statement. Then page 74 is the impugn order. 74.
So in this status quo order,
Yes.
government could have indicated, instead of saying matter pending for the High Court, or while indicating that, they could have also indicated that the party has already gone for seeking relief before the registrar. And that's why the government will not take any decision at this stage, because it is for the registrar to consider,
Lordship, in
which
para-
supports your counter affidavit
Lordship, in par-
that all matter pertaining to the function of society registration is before the registrar. So that is why, unless let him decide, government has no role. You could have said that.
Exactly, Lordship.
But this, as it appears, you have taken the plea that High Court is taking up the matter, will not do anything.
Your Lordship, if you see the paragraph 21 in the affidavit, you have admitted that the action of Lota who is not appropriate.
Huh?
They have admitted in the affidavit. But paragraph 21, Lordship, page 15 in the affidavit.
See, now if you go to that controversy regarding registrar's power or not, this, that, then we'll need more documents. We'll need more, whatever you have, the memorandum of association and whatever thing you have, and what are the powers and function of a registrar. Only then the court will be able to appreciate everything and come up to a conclusion, isn't it? Right now, that thing is not there. On one part, you say the HO has no role to decide such kind of things. At the same time, you're also challenging the registrar's decision. So registrar is supported by the government. They say that yes, the registrar can do it. He has the power. And I think private respondent also will support. So this registrar has the power. Let him decide.
Your
We'll
Lordship-
see your strength, whether you are actually popular or we are more popular. So to appreciate all these things, we need more materials, you see. That is the thing.
Lordship, in the affidavit, you have said that since they have
Page-
on page 15, paragraph 21.
21.
Here they have stated, since they found the action of the Lota Ho to be not appropriate, he have directed the party to maintain the status quo. But whereas in the letter dated 10/6/2022, here they have not mentioned regarding the action of the Lutahu to be found to be not appropriate. In the fifth line, the unilateral action of Lutahu based on the grounds given by it were not found appropriate. In all the parties concerned were hence advised to maintain status quo. If they have taken a decision that in this order, that action of the Lutahu is not appropriate, in that case the matter would have come to an end.
Your Lordship, it's very sad that the petitioner wants the matter to be reverted back to the government where there is nothing to be adjudicated, so that they continue and complete the tenure, Your Lordship. That is the intention of the petitioner.
Tenure for which year? How long?
They will end this year,
Bishop,
Your
the
Lordship.
tenure will
The
end by
tenure as an officer.
this year December.
Yes.
This year, December.
Yes.
How long is the tenure? 5 years?
2 years. Lordship.
2 years. Then how is the next member elected?
It has to be elected by the general conference.
In the general conference.
If they admit so in their affidavit, let them come out with the order. Here the matter will end. Lordship.
Lordship, I have clearly stated that there is nothing, so beyond that, like asking us to give an order, it amounts to
No,
again putting pressure on us, Your Lordship. Yes.
He wants your admission, and if you admit, he will say, see, now they are wrong, so we are right.
The Lotha is wrong, Your Lordship. That's why.
Give
we
us an
said
order
that.
since the issue is the matter is pending before you.
And that is not the crux of the case, also, Your Lordship. The crux of the case is the management of the affairs of the LPCA.
No, this came only because of the Hoho's intervention.
No, Your
These are all
Lordship-
connected, you
Yes.
see. You cannot segregate saying that it is independent.
Exactly. And then in the
The role of the Hoho, in fact, they may be right or they may be wrong. Their main aim is to protect the interest of the Lotha tribe
Yes, yes.
and to see that the unity prevails.
Yes, yes.
People are not divided.
Yes.
This is their main intention.
So, Your Lordship, if we go through the memorandum of the Lotha Hoho, that is only for an interim, is only for a period of 6 months. So that has also already lapsed. If we go to the memorandum, Your Lordship.
No, that is okay,
Yes.
but the fact again remains that is it bad in law?
Yes.
The intervention of Hoho in such a manner, is it bad in law?
Yes.
That's also another question.
Yes, yes, Lordship.
While seeing that it is only for 6 months or 3 months or whatever, it's a different thing. But when the very inception of the particular decision by the Hoho is wrong, everything goes
Yes.
as per law.
Yes. So, Lordship, that is my submission.
Yes.
Yes, may it bless your Lordship.
Yes.
Here, I'd like to make a first reference to the status quo order
Yes.
and the memorandum adopted. Here, the 18/3/2022, when the Lotha Hohas adopted that memorandum, there the petitioners are taking shelter on that line also, and otherwise the petitioner, they are again trying to take a shelter on the status quo order which was passed by the Commissioner of Home, Government of Nagaland, on 10 June 2022. They are playing a double standard in this case. One, they are saying that the memorandum adopted by Lotha Ho is bad in law. Other way, they are saying that the status quo passed by the Home Commissioner on 10 June 2022, that should safeguard them. That is what your contention in this main case. Here, the status quo order does not preclude the respondent number 5. I am for respondent number 5. I was under the petitioner. But when the petitioner acted in such a way that there was a maladministration, misuse of power, everything, we have gone to an extent that unless and until we make a reformation in the setup of our Lotha Baptist Church Association, this cannot go on like this. So that is how the Lota Ho has passed the order, memorandum, but the state government has decided that no, it is ultra vires. Thereafter, we come into existence. We came into existence, opposing in mutinying against the petitioners.
No, who's declared ultra-virus?
Commissioner, government of Nagaland, saying that it's older virus.
Which one? What is ultra-virus?
The order passed, the memorandum passed by the Lutaho.
But commissioner is not the final authority.
No, home commissioner.
Opinion only, opinion shared by the commission.
Huh?
Not the final order, only so opinion.
Saying that it is ultra virus.
Where's that?
Yes, I will make a reference to that.
So why it was referred to the government then if he says it's ultra-virus? It has to be confirmed.
Page 61.
61. Type copy, it will be at 63. Last paragraph, my lord. I mean, we are allowed to read out. The office is of the opinion that the ordinance memorandum dated 18/3/2022 issued by the tribal ho should be considered null and void since it is ultra vires and also in the process of legal adjudication is pending before the Honorable High Court. The instant action of the Lota Ohu is in dissolving the existing LBC administration and replacing by a reconstituting a separate prudent interim LBC administration on its own volition at this juncture that amounts to interfere in the court proceeding and may be considered as an abstraction in the administration of justice and put established law under bad light. However, it is suggested that the NBC may be requested to make an attempt in resolving the impasse as per the direction of the Honorable High Court. Moreover, it would also be prudent to solicit the views and the comments of the Justice and the Law Department to enable the government in taking a well-informed decision. So that is the view given by the state government. Now,
Commissioner Nagaland.
Yes, Commissioner of Nagaland.
Not Home Commissioner.
Commissioner, my lord. Under its signed Commissioner.
Exactly. So,
and he forwarded to the government. So, according to that,
how did he forward? Oh, it's okay. The letter is addressed to the Home Commissioner.
Yes.
And the reply came on the next page.
Yes.
Status quo.
Yes. Now, here they are saying that the present petitioner and the present respondent, as well as the state respondent, these should be covered by that status quo order. But here, the very aspect of the case is that under the petitioner, we were also working together. We were as a constituent judge under the LBC of 146 churches. We were them, with them. But when the action, everything was going beyond the control. So we come to understand that no, it should not be like this. So the program which was supposed to have been directed by the Lota Ho to be constituted on 18/3/2022, it was not the same prudent interim body. It was never come into existence because of the government interference and the complaint by the respondent. And only on July 29, the respondent number 5, under the bannership of the Lutha Baptist Church Associations, has called up a general conference of all the churches members of the LPCA. That is, the petitioners under whom the petitioners are working and under whom we are also there. But the petitioner refused to come and attend on that particular meeting, which was held on 29. So on 29, I'd like to take your lordship to this.
Shall we do one thing? Shall we continue tomorrow? How many matters are there? No, tomorrow. Just find out. We'll continue tomorrow. I'll hear you, then he might want to give a short reply. Then let's see what can be done.
Lordship, my reply to the respondent number 5, it will be very short. Since
It's okay.
it made it in the impugn order as well as in the affidavit. Your form only in the month of.
If it's short, it's better.
My
So
lord,
tomorrow,
yes, as a first item part heard, first item hearing.
See, there's already a list for tomorrow. So morning, somebody remind the court, and we'll upgrade the matter. After we finish the part 1 matters, before taking the hearing matters, we'll take this as the first item. Please write down, hearing remains inconclusive. List the matter again tomorrow for hearing as part heard. So normally part heard matters are given preferences,
Yes,
isn't
sir.
it?